item number 14 and 23. Well, the conducting council are for due to medical emergency has to rush to the hospital. I'll be fixed on Friday, my lord.
Mr.
Be that.
B. Das, learned counsel for the petitioner who submits that who prays for an adjournment on the ground of difficulty of the conducting counsel, Mr. R. Bora. Considering the submission, let this matter be listed again.
At least the item number 14, that is AB, my lord. That is my fix on Friday.
No,
14 and 24. 24.
Fixed.
23.
Fixed on. Give it a
28.
28.
Next is
28/11.
Yes. I beg to mention item number 41, my lord. Here in this case, my lord, CD was called for my lord. My lord, as per my CD is not available.
Mr. A. Munna,
Manna.
learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor, who prays for some more time for protecting his life. There is let this matter be listed. When it can be fixed?
It's from where? It's from where?
8/12.
Align.
You are on
8/12.
you are on
Interim, my lord.
Oh, he's on interim. So
8/12.
8/12.
8/12.
8/12.
The interim order shall continue till next.
Lord.
Maybe the lordship. For listing, my lord.
Listing of what?
DA matter, my lord. Already, my lord, 75% the end of our.
When have you filed?
My lord, 9.
When do you want it?
23rd.
Okay. Let it be.
23rd.
Lordship, I beg to mention item number 21, Lordship. With the consent of the other side, the matter may fix at 2 p.m., Lordship. Thank you.
It will go beyond 2.
Lordship?
It will go beyond 2. It will be taken up after bail hearing.
Admission after period.
Ele 2 p.m.
And then-
হয়ে যাবে।
For withdrawal, item number 1.
Item number C4. Delivery of orders for validate. Delivery of orders for delivered for it.
May it please your Lordship. Your Lordship, I beg to withdraw this matter.
How it Miss M. Hajorika. What
Yes,
is the S. Nevar? S. Nevar, who prays for allowing the petitioner to withdraw the instant criminal petition. The prayer is allowed. This case is dismissed on withdrawal.
For delivery of orders, item number 16.
Go to item. So keep बताओ. For reasons mentioned in the order, this interlocutory application is dismissed. And however, considering the grounds taken in the connected appeal, the applicant shall be at liberty to make a separate prayer for out of turn listing and expeditious hearing of the connected appeal.
For motor PA, item number 2.
May I please? Lord, 439 application, my lord. Lordship, find the Azhar at this 30.
He got severe injuries and he is in a very serious condition.
Is there would be required.
So medical report along with the CD?
Heard Mr.
Yes, yeah.
S.A. Ahmed, learned counsel for petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of injuries sustained by the victim in this case, perusal of the case diary as well as the injury report would be necessary. Hence call for the same fixing.
Next week, Jorhat, 29, no, 29 November? No, okay. December 4th,
Let this case be listed again on
Yeah.
4th of December.
10th of December. Okay. 10th is a Sunday, so 11th,
11th.
11th of December.
Obliged.
In this case, CD may be called from myself.
Heard Mr. A. M. Ahmed,
Fake doctor. Mm.
learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Call for the case diary fixing
Group B, 4th December.
4th December.
Item number 4.
Therefore, 39 bail allegation. Allegation is a T76, T25.
Case diary would be
Lordship.
heard Mr.
Take up.
Heard Mr. What?
Take up.
Sheikh
Abdullah.
Sheikh Abdullah, learned counsel for the petitioner, also heard Ms. S. Jahan.
From the
Call for
So
the case diary.
Kamrup, 29th of November, Kamrup.
We
I-
may be having lot of cases.
Acha, 5th of December then,
5th of December.
5th of December. Oh. Oh.
Please, Lordship.
Kiso.
It is a 439 application, bail application, Lordship, under Taluk by case number 607 of 2023 under section T26, Lordship. Lordship, FIR.
326,
Lordship.
grievous injury.
Yes.
Case diary would be required.
Lordship.
Heard Ms.
The allegations are against some animation. The petitioner is sued. Oh, I do it. So CD.
Heard Mr. M. Bishwas. M. Bishwas. SK Das.
SK Das.
SK Das, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. Let the case diary be called for fixing
6th of December.
6th of December. for case diary.
Right.
Fifth is a holiday, Nikita. Fifth is a holiday.
Maybe. Lordship, here, I have changed the impugn order dated 29, 2013, page 65.
Maintenance allowance.
Lordship,
Hmm.
there is some, before going to the impugn order, Lordship, may I paper some facts of this? So, my signature has been taken forcefully.
Where is the impugn order?
Impugn order is page 65.
To whom the maintenance has been allowed? Who your,
Lordship, what happened? My signature in one occasion has been taken forcefully by the opposite member, others and opposite party members. Subsequently, that documents has been converted into marriage certificate. I have challenged that marriage certificate in the committee court. Your Lordship, is final page 23. FC civil case number 327 20.
Ma thing will not come. The seized vehicle was used for transporting the illegal drugs, and separate chambers were constructed inside the driver.
none appears for the petition. Let us wait for the
Not,
petitioners come
yes, might
because
turn up. Not.
Yeah, please, Lordship. Lordship, in this case, I am challenging the order dated 6/11/2023, passed by the Judicial Magistrate First Class in DP case number 183/2022, Lordship, by this order, the learned judicial magistrate has restraining the petitioner from entering into her shared household. Lordship, I was residing in that house and since the day of my marriage. Lordship, there has been 17 years of my marriage. Lordship, last year my
You are
husband.
husband or wife?
Lordship, I'm wife, Lordship.
Okay,
Lordship, this domestic violence case has been filed by the mother-in-law.
okay.
Lordship, last year on the 7th July 2022, my husband died, Lordship. Lordship, thereafter, my mother-in-law filed this domestic violence case. Lordship, kindly peruse the impugn order, Lordship. Case number 161, Annex 14, Lordship. Lordship, the learned court below, while the passing this order, there has not shown any ground of a domestic violence. Only the ground is there that
161.
yes, Lord. Lordship, Annex 14.
Yes.
Yes, Lordship, in this case, while passing this order, the learned court below has not given any ground of a domestic violence against the mother-in-law, Lordship. The ground is that the property where I was resided and my mother-in-law was resided, that property belongs to my father-in-law. And it was the self-record property of my father-in-law. Since Lordship, my husband is there in the last year, so my husband's share is there. And the Lordship, I was residing there since the day of my marriage. And now the learned court below by passing their order, Lordship, restraining me from entering into my share household. And the Lordship, in this case, I also filed a domestic violence case. And I am seeking for the share household and a residential order, Lordship. That case is pending, Lordship. Lordship, my prayer is that the operation of this order may be stayed, Lordship, because Lordship, my belongings are there. This Lordship, by taking the advantage of this order, my belongings may be thrown out. So Lordship, this order may this order passed by the learned court below, Lordship, may be stayed. So Lordship, my submission is that the order may be stayed, Lordship.
Heard Mr. S. Deori, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Srimati Meenakshi Mahanta Brahma, impugning the order dated 6/11/2023, passed by the Court of Learned Judicial Magistrate First Class Kamrup Metro in DV case number 183/2023, whereby the learned judicial magistrate has prohibited the present petitioner from entering into the property of the petitioner's deceased father-in-law, which is the shared household of the present petitioner also. Stop. Learned. The impugn order dated. Who has filed this DV case 183?
Lordship, my mother-in-law, Lord.
The DV case number 183/2023 has been filed by the respondent, who is the mother-in-law of the present petitioner, alleging domestic violence on her, in which and in the said DV case by order dated 6/11/2023, following order has been passed. Quote the order from the. It is submitted by learned counsel for the petitioner that while prohibiting the present petitioner from entering into the shared household, the only ground mentioned in the impugn order is that the said property is the self-acquired property of the father-in-law of the present petitioner, and no other ground has been mentioned in the impugn order. Learned counsel for the petitioner submits that the husband,
Yes, Lord.
your husband is alive.
No, Lordship, died.
The husband of the present petitioner was the only son of the father-in-law of the present petitioner, and as such, she is also entitled to a share of in the shared household, being the legal heir of her deceased husband. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice on the sole respondent by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. In the meanwhile, as it appears from the submissions made by learned counsel for the petitioner, as well as the materials placed on record, that the present petitioner is also a legal heir of the deceased Ishan Chandra Brahma. Hence, it appears that the order, prima facie, it appears that the order whereby the present petitioner was prohibited from entering into the shared household does not appear to be justified. Hence, till returnable date, the operation of impugn order dated 6/11/2023 passed in DV case number 183/2022 by learned judicial magistrate first class is hereby kept in abeyance. Let this matter be listed again after court.
Okay, sir.
Item number 8.
May it please your lordship, my lord, this application under section 482 CRPC, my lord, challenging the taking of cognizance, my lord, under section 417, 420, and 406, my lord. My lord, page number 9 was the FIR, my lord, from which the charge is filed, my lord. Page number 9, the lordship will find that this is a dispute of civil nature, my lord. My ground of challenge is only that, my lord, that the informant alleged that the petitioner here in, my lord, was to sell his car, a small car, for which he paid rupees 50,000 to him, and he did not, my lord, deliver the car. This is the short FIR, my lord. Page number 9, your lordship will find. No, nothing is there, my lord. Where is the agreement? What was the amount of the car? How much amount he paid? Nothing is there, my lord. And this is
But
reflected, my lord.
allegation of cheating is there.
He used to abuse me and threaten
threaten.
Yes, my lord. Page
if
number
I ask for money.
12 for a moment, my lord. While allowing the anticipatory bail to the petitioner, this honorable court observed this, my lord, page number 12. The last, my lord, last 2 lines, my lord, made informant in his FIR has made a vague allegation that the accused petitioner, after taking 50,000 from him, has not delivered his vehicle, which he was supposed to sell to him. The informant has not mentioned the nature of agreement between the parties or the amount fixed for such sale, my lord. So, my lord, this is the observation of this honorable court, my lord. And, my lord, that cognizance order, my lord, your lordship will find page number 18. Page number 18, my lord. No ingredient of 406, my lord. 420 is also not there, my lord. 470, 420, and 406 taken, my lord. No ingredients is there, my lord. Prima facie, my lord, in the FIR and the charge sheet also.
406 can be there because it is misappropriation. It is
How, my lord, I will
Right,
read the
yes.
definition, my lord.
Perusal of the case diary would be
Nothing was, my lord. Nothing
Because-
was, my lord.
magistrate has opined that sufficient materials
Mm.
are there.
But, my lord, it is not sufficient, my lord, because, my lord, in a case of, my lord, Devendra and others, or 2009-7 SCC, the Supreme Court, my lord, mentioned that is to be reflected in the order, my lord.
The order should reflect, my lord, that the ingredient is there or not, my lord. I have a copy, my lord, of the judgment, my lord, perused, my lord. That, my lord, there should be a reflection in the order.
Otherwise, cognizance is nowhere defined. It is only taking note of the case.
Yes.
So the orders, some
No, but
detail order is not perhaps required in a cognizance order.
and otherwise, some reasons are mentioned. There are
Nothing is there, my
Sufficient.
lord. In this case, my lord, nothing is mentioned that where there is an agreement for the amount. My lord, may I refer page number 28, my. Sorry, my lord, paragraph 28, my lord, please. Sir. Seven. Paragraph 28, my lord.
yes,
Further, in a case this nature where even according to it has thus no case has been made out for taking cognizance of the offence under section 420 of the penal code, it was obligatory on the part of the learned chief judicial magistrate to apply his mind to the contents of the charge sheet. So, my lord, nothing is
this is the
mentioned.
submission.
Such on my lord, lastly, my lord, paragraph 29, however, must place on record that we have not entered into the merit of the dispute in civil suit. The same has been determined in accordance with law.
There
We
is no
request that-
finding or conclusion as such.
So, my lord, my humble submission is that, my lord, since in the bail application, my reasonable court observed that this is, my lord, a bag allegation, my lord.
Okay, we are issuing notice, but this is not a case of where you will get any interim relief.
My lord, otherwise, my lord, this is an amount of only 50,000, my lord, and
Maybe.
this is my lord. Otherwise, the case of the petitioner is that, my lord, the fact is that it was a borrowed amount.
No, we have to go through the material.
Yes.
Notice and CD will do because in the cognizance order he has written, I've gone to the CD and all.
Yes,
So CD will make it clear.
LCR.
Oh, LCR.
LCR, my lord.
scan
LCR
copy of
will-
the LCR.
LCR.
along with the case diary, yes.
How Mr. M.J. Kadir, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional for petitioner. This application under section 482 of the Code of Criminal Procedure from 1973 has been preferred by the petitioner Azharul Islam, impugning the order dated. Which order?
18, my lord, 18, page number 1.
Order dated 18/7/2022 passed by learned Judicial Magistrate First Class
And subsequent order.
Agree.
also, my lord.
in PRC case number 2072/2022 under section 417, 420, 406 of the Indian Penal Code, and also for quashing the proceeding of PRC case number 2072/2022 pending before the state court. Issue notice to the respondent. Since learned additional public prosecutor has received notice on behalf of received notice for the respondent number 2, no formal notice need to be issued to respondent number 2. However, as regards respondent number 1 is concerned, the petitioner shall take step for issuance of notice on respondent number 1 by registered post within 3 days from the date of this order, returnable after 3 weeks. Let the scanned copy of the case record of PRC case number 2072/2022 pending in the Court of Judicial Magistrate First Class, Dhubri, along with the case diary of Gauripur DS case number 66/2022-2020 be called for. Let this case be listed again on
Particularly on 21st of December or 20th of December
20th of
of life.
Item number 9.
9, I think, scan, 10, 9, 9, 9.
Well,
Nine, nine. Okay. 9 to 9.
Well, okay. This is a matter substituted case matter,
Good to
and
9.
petitioner is before a relative is a teacher matter. 9.
In fact, a scan copy was called for, but it is not here
No,
today.
no, this is the
No
first.
scan.
first
Oh, acha, acha, acha.
No
Somewhat
scan was
written
called
in
for.
my
This is
copy.
the first step. The petitioner before relative is a teacher matter, and my lord, informant is matter his sister-in-law matter. And kindly look at matter, page, FI is matter, page 14. The matter, the occurrence took
Now,
place.
what stage
what-
the case is pending now?
Case is pending matter before the page 20 matter.
At
Lord.
what stage it is pending?
One matter,
Seen the charge sheet. Charge sheet was
Sir.
seen only, no cognizance was also not taken up.
page 20 is the last one. The entire matter,
It was made over to
FI was on matter 26/7 and Sasi submitted matter on 10/10/2020.
One order
3 years
is,
matter, and matter, he is a teacher matter, the petitioner is a teacher, in matter, inquiry never matter took about it. No inquiries,
no, perhaps it has come up for the second time. I don't know. There's an order, a stipulation made in my
That's
copy
fine,
that 14/11, there was an order, 14/11/23.
14/11, there was
the
an
adjournment order.
adjournment order.
Oh,
adjournment.
adjournment. Acha, acha.
Yes,
In fact, no, the allegations are there. I mean, these are those.
After more than 1 year.
Acha. So 1 year ago, there
1
was
year.
there was the allegation, but then later on he blackmailed and raped her for several occasions, and
In fact,
Showing
matter,
the video.
informant knowledge is still in his house.
she tried to attempt suicide on 1/5, and the Ejahar was lost 2 months thereafter.
yes, very
Huh?
good to record.
It's very
It is a Sasi.
oh,
And scan
traffic.
copy of the,
I have already
Scan-
annexed my letter as Sasi.
The scan copy of the LCR along with
Hello.
the case diary.
heard Mr. Heard Mr. M.R. Khandokar.
No, telephonic. This is item 9.
This is item number 9.
9, yes.
Heard Mr. A. Khandokar, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the FIR as well as in the charge sheet, the perusal of the scanned copy of the PRC
My
case
object-
number 2353/23
Along
along with the case diary of Sonapur PS case number 148/2023 would be required. Hence, call for the scanned copy of the both the case diary as well as case record.
I am paying for ATM matter. Otherwise, my police maybe have got.
No,
I'm a serviceman matter.
you will,
I'm a
the
teacher matter.
court will issue only summons.
No, now police is employing me.
No,
That's why I'm
why?
coming to my lord before your lordship. Otherwise, I would wait for issuing summons matter. Now police is matter searching. Now, my lord. That's why I am before your lordship.
He's shown as an absconder.
It's just shown as a responder matter.
No, but after submission of charge sheet, unless there is a warrant by the court,
No,
why police will.
That's why police searching me. That's
That is improperly done if they are searching.
It's not a next time, not returnable that matter. No.
No. Only after perusal of the material. Let this case be listed again on.
General report.
Coming.
For December or whatever.
December. December.
Some
16th
earlier,
timeline.
otherwise, he's in December, now he's not.
No, your submission is not very.
Not
Now
in
there
compliance
is-
with the law matter, but police
Now-
searching is valid.
Not believable
I
because
mean, he cannot
after-
have the apprehension now about being
Even
arrested.
police came to my school, man. Otherwise, I have to wait matter for students, matter, someone. When the police came to my school, then only I came to know that this case is not pending.
Where is the statement that police is that? No, let the case very.
Well, it's there in paragraph 6. Police authority without searching the issued notice against. Oh, acha, acha, for
Okay.
There is no such thing.
There is no statement.
For 4th of December,
Fourth of
Okay.
December.
4th December.
Item
Give
number
them.
10.
I believe your lordship, lordship 438 application matter. FIR page 13. Page 13, 1-3. The allegation is that my lord, on that day, the accused number 1, who is the present petitioner, fled away with the wife of the informant, my lord. The wife of informant, my lord, in the page 14, it is mentioned her age was 23 years, my lord. So there was a love affair, my lord. In the affair, there is no force, no kidnapping, my lord. So 366 is, may not be acceptable. He willingly went to the went with the accused petitioner, and also she case 18, my lord. By herself divorced her wife, divorced her husband, who is the informant. Case 18, that lady, my lord. My lord, paragraph, my lord, page 19. Page 19, paragraph 4, my lord. May I read, my lord?
Okay, okay.
that-
No, okay, she divorced.
My lord. Thereafter, my lord, page 20, the lady entered within marriage agreement, declaration, my lord, page 20, with the present petitioner. This major, my lord, consenting party, there is no court, nothing, my lord. Willingly she went to that.
It seems the 366 will not be attractive because the word uses fled away my wife. It's not like he took away my wife. It's fled. Both of them went together. 366 ingredients are less. 379 case theft. This is 1,50,000 that the wife had taken.
Their wife has taken.
And 34.
Lord Mr. M. R. Khandokar, learned counsel for the petition. Also heard Miss S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rafiqul Islam alias Rafiqul, who is apprehending his arrest in connection with Gwalpara PS case number 407/21 under section 366/379/34 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 6th of July 2021, one Anwar Ali had lodged an FIR before the officer in charge of Gwalpara Police Station, inter alia, alleging that on 5th of July 2021, the wife of the first informant fled away along with the present petitioner with 7-month-old child, and the wife of the first informant also took the golden ornament and golden ornament of about 1,50,000 value and other materials along with her. Learned counsel for the petitioner has submitted that the victim, that is the wife of the first informant, is an adult woman of aged about 23 years of age, and from the bare perusal of the first information report, it would reveal that the first informant's wife fled away, accompanied, eloped with the present petitioner on her own. It is further submitted by learned counsel for the petitioner that thereafter the wife of the first informant, within bracket the victim, had the
20.
had divorced the first informant, and after executing a deed of declaration of marriage is living with the present petitioner on her own. Where is the
Now, my lord, the lady is with the husband.
Which
With the
first
with
informant?
the petitioner?
with
With the
no petitioner, with the informant.
oh, with the informant.
My lord. In between something has happened, now he is living with her. Hardly enough.
Now, why in a case which was registered in the year 21, it is in the year 21?
Yes. Thereafter, with some compromise, delays meeting.
Why are you apprehending your arrest now?
Because my lord, police.
The learned counsel for the petitioner has submitted that the petitioner is now apprehending his arrest in connection with this case, as the victim has returned back to her husband and is now staying with her husband, that is the first informant, and police is searching for the present petitioner. So CD would be required, or can we dispose it of? Let him appear.
My lord.
Let him appear.
Let him appear. Lordship will dispose.
Considering the fact that the FIR was lodged about more than 2 years ago, that is on 6/7/2021, and also considering the fact that the bare perusal of the FIR would reveal that it was the victim who herself eloped with the present petitioner, and also considering the fact that the victim was a major woman, an adult woman on the date when the alleged offense was committed, further considering the submission made by learned counsel for the petitioner that the petitioner is ready to cooperate with the investigating officer, this court is of considered opinion that custodial detention of the present petitioner may not be necessary for fair completion of the investigation of the Goalpara PS case number 407/21. Hence, the petitioner Rafiqul Islam is hereby directed to appear before the investigating officer of Goalpara PS case number 407/21 within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Goalpara PS case number 407/21, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that he shall cooperate in the investigation. With above observation, this anticipatory bail application is disposed of.
Not.
Highly obliged.
Item number 11.
Next, please, Your Honor. 438 application of lordship, certificate method, lordship will find FIR page 9. After missing of the son of the informal lordship, FIR was lost without naming anyone lordship. And after investigation, police submitted charge sheet that your lordship will find start from page 15.
I'm taking your lordship to the relevant page, lordship, page 20. This is the type copy. May I read?
Charge sheet is against you also.
I am shown as only absconder, but here the investigating officer categorically said evidence was found against other three accused persons. Last paragraph, your lordship will find, during investigation, a prima facie case under circumstances has been found well established against accused person Hussein Ahmed, Nurul Nisa, Bodrul Haq. They have been arrested and forwarded to the judicial custody. And accused Ziabur Rahman. Ziabur Rahman is before your lordship. Ziabur Rahman has become absconder to avoid arrest. So only their allegation is that I absconded. I was not named in the FIR. I was not aware about that. Lord. I have no knowledge about that. I will face the trial with whatever is there. Lord.
Now, why are you apprehending your arrest?
Because they have shown me as absconder, Lord, and if I appear before the committal court, because this is a sessions triable case, I will be taken into custody and will be forwarded.
What stage the committal case is pending? Whether
The
summons have been issued?
summons to my instruction, Lord, it is placed before the court. Lord. But about summons, he is not aware. He has not received any summons in there.
Lordship, since the matter has been solicited, motion may call for the scanned copy of LCR along with the CT attesting.
No, even if we call for the scanned copy of the LCR, his case is different. His case is that the case pending before the committal court is a sessions tribal case
Lordship,
in which even if summons are issued, the committal court would not grant him bail because of the, where is the embargo?
209 subclause A.
209 subclause A and 437
430.
1 subclause 1. 209 would come only at the time of committal,
Committal.
yes,
but before that, whether committal court may grant you bail or
No,
not.
under section 437, he cannot.
Let him appear. Where is the charge sheet?
Page 15, start from page 15, Lord.
Or let us see the scan copy, because sometimes IO does not write in so much of detail in the charge sheet,
Lordship.
but otherwise
But even then also, Lordship,
Just want to see the last order, Lordship.
I have given one copy of your Lordship's order. Where Lordship, he was not named in the FIR. Subsequently, police filed charges showing him as absconder. And as the case was sessions triable, he was allowed to go.
no,
bail.
otherwise you have a case. What is the status of the other accused persons who are named in the FIR?
They were arrested and subsequently released on bail.
Released on bail.
Right.
Okay, heard Mr. A. Ahmed. Let him appear.
Lordship,
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ziaur Rahman, who is apprehending that if he Ziaur Rahman, who is apprehending that if he appears before the committal court in connection with PRC case number 1205/2023 pending before the Court of Learned Judicial Magistrate First Class 2, number 2, Karimganj, he may be detained behind the bars. The list of accusation in this case is that on on 12/7/2023, one Jyotish Kumar, one Abidur Rahman lodged an FIR before the officer, before the in charge of Barai Grao police outpost under which police station?
Karimganj,
Patharkandi. Patharkandi police station, inter alia, alleging that the son of the first informant went missing on 11/7/2022. And on the basis of the said FIR, Patharkandi PS case number 3169/22 under section 363 of the Indian Penal Code was registered. Later on, section 120B, section 201, section 302 of the Indian Penal Code was added to the said case. And after completion of the investigation, charge sheet was laid against 4 numbers of accused persons, including the present petitioner. The present petitioner has been shown as an absconder in column number 2 of the charge, column number 3 of the charge sheet. What is your name? Siraj?
Ziaur Rahman.
Yeah. Learned counsel for the petitioner has submitted that on perusal of the charge sheet, it appears that the investigating officer of the charge sheet has mentioned there in the charge sheet that that during investigation, prima facie materials against the petitioners, against the accused persons, namely Hussain Ahmad, Nurul Nasa, and Badrul Haq, has been found. However, nothing has been mentioned as regards the present petitioner, and he has only been shown as an absconder. Learned counsel for the petitioner has further submitted that the case has now been. Where is the order?
That order I have not annexed.
Now, how will we know that it is pending? It has been that it is pending for committal.
That I have made a statement in court title also. Lord.
Now, before which court this committal case is pending? That
Before the page 2, first line, your lordship will find Court of Judicial Nature, first class.
no, apart from your statement, where is the material?
That I have not said.
That we have to otherwise, because only on your submission there has to be something to substantiate your either summons or some record. There, what was that? Case is now pending for committal before the court of learned.
PJM. That's too correct.
Where is the paragraph? In which paragraph?
Page 2 of my petition, lordship. Top your lordship will find. Start
Before
from
the
page
court
one.
of judicial may. So
JMF.
presently there is no application. At present there is no such application.
But I have been shown as absconder, so if someone, if on receipt of someone he appears, he would be.
No, it appears to be premature. We have to see pending in the Court of Judicial Magistrate First Class Number 2, Karimganj. However, apart from the statement made in the bail petition, nothing is before this court to verify as to before which court the case, PRC case number 1205/23 is pending, and what is the stage of the said case so as to ascertain as to whether the apprehension shown by the petitioner of being detained in connection with the said case is genuine or not. Hence, call for the scanned copy of the case. Read scanned copy of the case record of the PRC case number 1205/2023 from the court of the JMFC number 2, Karimganj, along with this case diary would be necessary.
Perhaps not. Because only this, whether summons has been issued or not, matter has been submitted.
And let us see what materials are there.
Let us see that. Then along with the.
Along with the case diary
Yes.
of Patharkandi PS case number 169/2020. Let this case be listed again on
Any date is for the convenience.
13th.
Obliged.
Obliged.
Item number
Yes, please, your lordship. 438 application, my lord. FIR, my lord, case 9, my lord. Mary Dumain, my lord. See, my lord, it is that committed.
Allegation of rape is
My lord, Mary Dumain, kindly see the FIR.
Page
9, my.
Page 9 is the translated part.
Yes.
My lord, what happened, my lord? My lord, as per allegation, my lord, I committed rape, my lord, on her, my lord, on 23/10/2023. But my lord, affair was lost, my lord, on
Delay.
8/11/2023 without citing any delay, reason for delay. Another, my lord, aspect, my lord, as per on 22/10/2023, I committed rape, and on the following day, my lord, on 23/10/2023, he, my lord, went with me to my lord see puja, my. As per the allegation of the affair, my lord. So, my lord, there is sufficient ground to disbelieve the fact, my lord, allegation, my lord. And my lord, actually, my lord, family dispute there, my lord, and she is married, my lord. But even, my lord, she pressurizing me, my lord, to marry her, my lord, because she is not happy with her married life. Totally, my lord, on court. So, my lord, I will appear, and till then, my lord, protection.
Let us call for the case diary.
Or after perusal of the case.
No.
My lord, actually, my lord, is a false.
Let us find out whether it is false or
My lord, my lord, statement is required for a witness.
heard.
Possible,
Mr. S.H.
Sikdar.
Sikdar, learned counsel for the petitioner. Also heard Ms. S.H. Gora, learned additional public prosecutor. Considering the submissions made by learned, considering the nature of allegation leveled against the present petitioner in the affair, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary.
On 13th.
13th.
In my lord, in the affair, my lord, mother also, my lord, not supporting the allegation as per affair. It's possible, my lord, protection.
CD will reveal.
Kindly, my. As per allegation, my lord. Mother also, my lord, did not support her. Okay. When my lord, middle, my lord, then when I informed my mother did not support. And my lord, protect my lord. She is married woman, my lord.
Give a shorter date.
On 8/12.
7th.
Obliged.
Obliged. Where 438 at page number 8, man.
I am a home guard, my lord. Allegation that, my lord, one passenger was allegedly, my lord, looted from a train, my lord, and it has been suspected that I, along with two other home guard, has looted that passenger. It is the allegation, only suspicion. Is because we were deputed in taking duty, my lord, in that train.
And they fled away from their police station on 29/10/2023.
Perusal of the case diary.
My lord,
Yes.
no such passenger has complained against us. It is provided in the train itself, my lord, through online or through SMS, complaint can be made. No such allegation has been brought against us, against me. And I am home guard, my lord. Kindly come to page number 15, my lord. Certificate, my lord. We will not abscond anywhere. Let me appear.
No, it is only suspicion.
Yes.
The
Let-
language is suspicion.
Let them.
Heard, Mr.
Yes, sir.
Heard Mr. H. Ali, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Tafikur Rahman, who is apprehending his arrest in connection with Guwahati GRPS case number 223/23 under section 120B/392 of the Indian Penal Code. The gist of accusation in this case is that on 3/11/2023, one B. Doimari, ASI of police, lodged an FIR before the officer in charge of Guwahati Railway Police Station, inter alia, alleging that on 28/10/2023 at around 11 p.m. some gold ornaments and some other valuables were looted from one of the passengers of Agartala Kanchenjunga Express. Kanchenjunga Express when the train was there at platform number 3 of Kamakya railway station. And during inquiry, the present petitioner along with the other home guards were not found in the police station, and therefore it was suspected that the present petitioner and along with the other two home guards are involved in the offense alleged in the FIR. Learned counsel for the petitioner has submitted that the petitioner is innocent and is in no way involved in the offense alleged in the FIR. It is further submitted that in the FIR only suspicion has been made against the present petitioner, as they were not found in the police station when the alleged incident had occurred. Stop. On the other hand, an additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant bail, anticipatory bail application. Hence, call for the case
1812.
1812 for case diary. However, considering the fact that at this stage, the perusal of FIR reveals that it is only the suspicion against the present petitioner and other two home guard on the basis of which the FIR has been lodged, the present petitioner namely Afikur Rahman, is hereby directed to appear before the investigating officer of GRPS case number 223/23 within 10 days from the date of this order and cooperate in the investigation. Stop if he does so within the stipulated period of time, in the event of his arrest in connection with GRPS case number 223/23, he shall be allowed to go on interim bail of rupees 30,000 with 1 security of like subject to the satisfaction of the arresting authority, with a condition that the petitioner shall cooperate in the investigation. Let this case be listed again on 18th of December.
Okay, 15 and 16 arising out of the same affair, the lordship may take after both are made together. 16. And
Which will be take first? 15,
16 lordship.
16.
Lordship. Placing the fact lordship before placing the affair lordship. What is happened lordship? The subject matter of the case deals with land dispute. This petitioner number 1.
In 16.
Yes, in 16, petitioner number 1. He purchased a plot of land measuring 1 vika, 10 lakh. But this land is a Exunia Patra. Is the Exunia Patra land and have annexed a sale deed. Thereafter, he was given the, because this land neither can be sold or mutated, so the position has been handed over to him. And after obtaining the position lordship,
Who handed over position?
Yes, that lordship would be pleased to have annexed the sale deed at the page 10 lordship. And the original one, since it is Exonia Patra land, this sort of agreement are executed, and page 12 is a copy of that. And the translated part lordship would be pleased to find at page 10, annexure 1. A purchaser Najmul Haq Chaudhary, so-and-so Hassan Ali, so-and-so, vendor lordship Joed Sayedullah. He is the man lordship. He has sold this 1 vika, 5 lessa, wherein 2 houses were erected. It's a very temporary house, thatched house lordship. And that has been, that position, that possessory right has been sold out with 4,50,000. And thereafter lordship, what has happened? He kept that land was there only. But this informant, what has happened? He on 25/10 lordship, he went there along with his goons and all, and then burned down the houses. And then this petitioner, although his case has been registered in a later phase, as he could approach the police station at a later stage. So his case has been numbered as 308 of Samuguri PS case, and lordship would be find at page 26 lordship. Page 23, received and registered by Samuguri PS case 308 of 23 under section 447, 449, 447, 447, 421, 436, I think. This is his affair lordship. Najmul Haq Hassan Ali, one of his associates, filed this affair, and page 25 is the affair lordship. The contents. May I read the contents, lordship?
No, that affair we are not concerned.
Yes. Now, lordship, that is the affair
That is the affair filed by you.
Yes, lordship.
Alleging that
Yes.
the informant came to
Yes.
your land.
Yes.
But what is the affair against you?
Yes, that lordship would be pleased to find that at page
14 onwards.
Page 14, lordship.
Why you are apprehending it?
Yes, I'm
in connection with this affair,
in connection with this affair, Lordship.
which is
Relevant part is page 15, Lordship. Now their contention with you, may I read the contents, Lordship,
Yeah.
page 15.
Yeah.
With due respect, I beg to state that since the year 2015, I'm living in a plot of land after purchasing the said land measuring 1 acre 10 lessa, but the above mentioned accused number 1, that is the petitioner 1 here, Lordship, mutated the same in the name by way of forgery on 28/10/2023 at about 11 to 12:30 p.m. The above named accused person comprising of 20 to 25 other persons trespassed into my land and threatened with their and 3 guns and their hands, burned down plastic and food of 2 houses, and also beaten 5 members of my family and injured them grievously. Right now, they are under treatment at Nauka Medical College Hospital. Many of them goods has been destroyed in this fire ignition, approx value of 1 lakh. Therefore, it is required, and the same sections have been incorporated here to Lordship, page 16, 147, 148, 149, 447, 325, and 330. All are available, Lordship, except 436. All are available, Lordship. And that clearly shows that was a public riot, mob was there. 147, 148, 149 are there. So this is the situation, Lordship. In fact, Lordship, this is very disputed fact, Lordship. Now, this actionia land cannot be mutated, Lordship. It's a government land, Lordship. How can one person mutate, Lordship?
no,
So
that is
Lordship,
not the dispute. Dispute is
Yeah.
whether you burn down the
Yes, 436 is.
In my case also, I have actually they have come to my place. They have burned up just to save their skin. They have this story has been projected. So Lordship, for balance of convenience and considering both the aspect, Lordship, that I have also lost the counter affair, cross affair exists, Lordship, and considering all the person, Lordship, and here in page in case number 15, Lordship, also I have made two cases because those are all senior citizens. They are only Qadis, Lordship. They are the religious persons. In other case, Lordship, I am referring for item number 15. They are Lordship 3 persons. Hassan Ali, they are the senior citizens. That is why I made a separate application for them. All are above 60. They are just with our approach, they have come to just solve the problem, solve the dispute, Lordship.
No, you separated the case because 3 petitioners are senior citizens.
Yes, Lordship. Exactly, Lordship. That is
So-
why I have started from page 16. I attend 16. I have made my honest submission before your Lordship. So my Lordship, at this stage, Lordship would be pleased to call for both the dieting. These petitioners may be protected. Similar cases, Lordship,
I think
for
Lordship,
ends of justice, Lordship.
the cross affair case.
Because Lordship, I'm going to show Lordship 325, because have there been any kind of major injury? Definitely there would have been Lordship 326. It is a case of 325.
It's a case of
That's-
436. So far, the
Yes,
affair
Lordship,
contents of the
436.
affair
Just
is
to make a
concerned,
case
Lordship.
of
Let us call for the case diary existing.
that
Lordship.
house, Lordship, burned down, and that is that to my premises. I have given prima facie, I have established it is my place, Lordship. They try to interfere. They try to intervene in the. They try to disturb, Lordship.
No, it is case of house burning.
Yes, Lordship. That is true. That is my house, Lordship. That is my house. Lordship, in the event, once the diary will come, everything will be cleared, Lordship. But if this
Okay,
petitioner
we are allowing the senior citizens to
Lordship,
appear before the,
Lordship.
in your second case, they will be granted interim.
after.
And in the first case, only after perusal of the case.
Up.
Third, Ms. T. Som, learned counsel for the petitioner, also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure. This is in item number 6.
16.
16, second case first. Item number 16. This case. What was the last? Has been filed by 10 numbers of petitioners who are apprehending their arrest in connection with Samaguri PS case number 307/2023 under section 147/148/149/447/325/436 of the Indian Penal Code. Considering the nature of allegations leveled in the FIR against the present petitioners, perusal of the case diary would be necessary. Hence, call for the case diary fixing
On 14/12.
14/12 for
Can it be? In all, it would be.
Because after 10 days, they have to appear before the IO lordship.
in
Very-
next case, in 15 earlier case, heard Miss T. Som, learned counsel for the petitioner, also heard Miss S.H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Hussain Ali, Safuruddin, and Hafizuddin alias Habizuddin, who are apprehending their arrests in connection with Samaguri PS case number 307/2023 under section 147, 149, 148, 447, 325/436 of the Indian Penal Code. The gist of accusation in this case is that one, Abdul Rahman had lodged an FIR on 26/10/2023, inter alia alleging that the informant has been staying in a plot of land measuring 1 bighah 10 lechas since the year 2015. However, the petitioner accused number 1 named in the FIR, namely Nazimul Haq Chaudhry, mutated his name in the against the said land by way of forgery, by committing forgery, and on 28/10/2023, the accused persons named in the FIR, including the present petitioners, trespassed into the land of the first informant and burned down 2 houses there, and also beat up the family members of the first informant. Stop. Learned counsel for the petitioner submits that the allegations leveled against the present petitioner in the FIR is not true. In fact, the accused number 1 named in the FIR, namely Nazibul Haq Chaudhry, is the owner of the land, which is a annual patta land, and as the annual patta land cannot be sold, the possession of the same was handed over to who purchased?
Petitioner.
To the
Accused number 1.
accused number 1, Nazimul Haq Chaudhry, who purchased the same from one who had purchased the possession of the same from one Saidullah. Stop. It is further submitted that the present petitioners, all the three present petitioners are aged person of 64 years of age, and are not involved in any manner in the offence alleged in the FIR. On the other hand, learned additional public prosecutor submits that as the allegation of burning the houses by the present petitioner is leveled in the FIR along with the other accused persons, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing what date was given?
14/12.
14/12. However, considering the age of the present petitioner, the all and nature of allegations leveled in the FIR, all the three above named petitioner, namely Hussain Ali, Safuruddin, and Hafizuddin, are hereby directed to appear before the investigating officer of Samaguri PS case number 307/23 within a period of 10 days from the date of this order and cooperate in the investigation. Stop if they do so within the stipulated period of time, in the event of their arrest in connection with Samaguri PS case number 307/23, they shall be allowed to go on interim bail of rupees 30,000 each, subject to the satisfaction of the arresting authority, with a condition that they shall cooperate in the investigation. Let this case be listed again on
14/12.
14.
Maybe. Is it for 30 days? Vishnu Milan, sir, one is Azhar Milord, page 8. As per Azhar Milord, the informant Milord called her, him Milord.
Case diary would be,
CD.
CD would be.
And allegation has been lost against everyone. There is no offense in English 376.
9/12. Doctor. 9/12.
Who is the victim? She is their relative.
Victim Milord, that is now both Rukia is the victim Milord, but she also I filed a case. My brother filed a case against her Milord. He also was arrested and now released by the Honorable Court on bail. And again, Milord, he filed a case against me, and for that case, I am here, Milord. There is Milord, no rap, nothing Milord, only the allegation is there. And as a Milord, he reached the house Milord. He is one part of body, he has been cut.
Heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the affair, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing
On 9/12.
9/12 for case diary.
In print Milord,
No entry.
2 minutes, date may be shortened with
Short date
Lordship, then 7.
7/5.
May I please, Your Lordship. Lordship, FIR is case number 13, Your Lordship. Relevant court, Your Lordship. May I read the FIR, Your Lordship? There is a delay of 34 days, Your Lordship, in lodging the FIR. Page 13, 1. The matter is settled. The local elderly people fixed a fine of rupees 80,000 on petition number 1. Accordingly, petition number 1 paid the amount to the local elderly people, Your Lordship. The local elderly people misused the said rupees 80,000 instead of to pay the informant. Informant is a married lady, Your Lordship, is 28 years.
But the incident occurred.
Yes.
Incident occurred on 34 days before, Your Lordship, and there is no issue of that incident, only issue of fine. already settled 180,000, your lordship, decided by the village bell, and the local elderly people misuse that amount instead to pay the informant.
No,
The
that-
petition number,
376.
That is not the issue in this case. Case is whether 376 happened or not.
34 days till before your lordship.
That we will
It's
verify.
a adultery, your lordship, not
CD will be
376, your
required.
lordship. Lordship, later part, your lordship, piece of
No,
Gawar
your
Dawani,
submission is this was consensual.
consented, your lordship. Lordship, second part, your lordship, piece of Gawar Dawani o Anan Murubbi Hokole, গাঁওতে বিচার করি 1 নং পদকের পরা 80,000 টাকা জরিমানা দিয়ে কিন্তু জরিমানা টাকা মোক আদায় নিদি মুরব্বী সকলে আত্মসাৎ কৰে আৰু কেছ দিলে মোক স্বামীৰ লগত সংসাৰ কৰিব নিদিব বুলি ভয় ভাবুকি দিয়ে। This is the local elderly people lordship, not the petitioner. The local elderly people lordship, petition number 328, your lordship. This is the allegation against them, your lordship.
No, no.
He is ready to receive the money, your lordship, and also pay, your lordship, with her consent, your lordship, rupees 80,000. Only issue of rupees 80,000, which already we paid.
No, no, that is subsequent
That is
to the
subsequent.
offense.
Earlier already settled, your lordship.
That is not mentioned.
And
that
that's a
is- that the
settled
matter
issue.
has
And
been
মুরব্বী
settled.
সকলে গাঁওতে বিচার করে 1 নং
বিচার
পদের
করে,
পুরা
village বিচার was
80,000
held.
টাকা লর্ডশিপ
Not
জরিমানা
settled.
কিন্তু জরিমানা
Third
টাকা মোক
Mr.
আদায় নিতে গেল।
Third Mr. A.A.R.
They can
Karim.
maybe call for like some protection mechanism.
Third Mr. A.A.R. Karim, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the affair, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
On 11/12,
11/12.
Some protection mechanism given your lordship.
not 80.
Says already settled, she admitted your lordship in the FIR itself.
No,
your
you
lordship.
protect yourself till then.
Sorted, your lordship. It's earlier.
It's
Ele-
from Pokrajar lot.
11/10 is the
11/12.
Obliged.
May I please, Your Honor? Lordship, I request the matter to be taken with item number 42 of the daily court list.
42 lot of CD is not available.
Sir, in item number 42, interim relief was granted to the co-accused in order dated 11/10/2023. My lord. My lord, this case arises out of a teenage love affair, where FIR was lodged 8 to 9 days after the incident. And my lord, all the family members and the distant relative family has been named in the FIR. FIR is at page number 16, my lords.
It's
16,
page number.
16, my lord. That is a translated copy, my lord. And 22 is the, my lord, the vernacular version of the FIR, my lord. A case under section 366 has been attracted, has been filed. May I read the FIR, my lord, in the vernacular language?
Yes.
সন্মান পূর্বে বিনীত নিবেদন এই যে যোৱা ইংৰাজী 22/9/2023 তাৰিখে আবেলি প্ৰায় 3:30 মান বজাত মোৰ ছোৱালী মিছ মেৰিনা বেগম বয়স 16 বছৰ 2 মাহ 14 দিন যে মোৰ ঘৰৰ পৰা উত্তৰ ভেৰুৱা গাঁৱত টিউচন কৰিব গৈছিল আৰু তেতিয়াৰ পৰাই মোৰ ছোৱালীজন নিৰুদ্দেশ হৈ আছিল কিন্তু আমি অনুসন্ধান কৰি গম পোৱা গ'ল যে মোৰ ছোৱালীজনী টিউচন কৰিব গৈ থকা অৱস্থাত উত্তৰ ভেৰুৱা গাঁৱত গাঁৱলীয়া পথৰ পৰা মোৰ ছোৱালীজনীক এখন বগা ৰঙৰ 4-চকীয়া গাড়ীৰ তলত নাম ও ঠিকনা উল্লেখ কৰা পদকীয়াগণে উঠাই লৈ গৈ কৰাত আবদ্ধ কৰি ৰাখিছে। Despite this, a case under section 366 has been filed. In anticipatory bail, my lord, in 3943, I am the brother of the accused number 1, who was in a love affair with the victim girl. since many
You
years
are
ago.
not the accused.
I'm not the.
You are the.
I'm naming
you
the
are
affair.
the,
Accused
you
number-
are the brother of the.
I'm the brother of the boy who has been in the love affair with the victim girl, my lord.
Okay.
Accused number 1 is the boy who has been in love affair with the victim girl. I'm the brother of the accused, my lord. And accused number, my lord, 3 and 4 and 6, my lord, were distant relatives, my lord. They have also been named in the FIR.
Your name. Your name is
Tofikul Haq, my lord.
number 2. Accused number 2.
Tofikul Haq, my lord.
Yes, doctor.
In anticipatory bill number 3943, my lord.
Okay. You are accused number 2. Now, where is the victim now?
My lord, we don't know anything, my lord.
Where is your brother?
The brother also we don't know, my lord.
Okay.
We don't know even hear about my whereabouts, my lord. The problem here is that, my lord, all the male members of the distant relative and the family members has been named, my lord. We are also equally concerned for our brother who is just 18 years old, with just certain majority. Now, my lord, we are apprehending arrest. We are not being able to find our brother also.
So your brother and the victim are missing.
Yet to
Yes,
be
my lord.
recovered, Lord.
Okay.
In Lordship, other way also, it ought to have been registered under section 366A of the IPC.
No, it's my lord 366. Sorry, my lord.
It ought to have been registered because
She is
victim
minor.
is a minor.
366. No, my lord. Intelligence of 366 they would not attract me.
Lordship kindly see,
Well,
victim
I
is a
have
minor, 16 years, 1 month, 40
No.
days.
Whether his role is there or not. Unless we go through the case right.
Lordship, that will be required.
However, my lord, we are from a very poor background, my lord. We don't have father, my
What
lord.
has happened to other co-accused?
My lord, in co-accused case, my lord, if I take my lord to page anticipatory bill 3512 for a minute, my lord. So, my lord, co-accused, has it? My lord has it.
Liaquat.
Liaquat Ali, and my lord, he is Rekibul Zaman.
Rekibul is Rekibul.
Rekibul Zaman. Now, my lord, if my lord comes to page number 35 of that petition, my lord has it, page number 35.
Oh, yes, make your submission.
My lord.
Make your submission.
Yes, my lord. Page number 35, my lord, he was in his office, he worked as a sales officer, sales manager in Tata Motors Bimal showroom, my lord. He was present the whole time, my lord, where interim has been granted. Now, my lord, what has happened that since he works in sale, he has to report his manager and he has to show his Google history. Therefore, my lord, in page number 36, he has also annexed all his Google history on the date of the incident, my lord.
Of Rekibul.
Of Rekibul Zaman.
No, we are not now taking up Rekibul's matter.
Okay, my lord.
We are Tafiqul
Might be on a
Salih.
different footing.
Only the query was whether Rekibul is on interim bail or not.
Rekibul and Liaquat Ali are on interim, my lord.
Interim bail.
Yes, my lord.
Okay.
And with Tawfiqul, my lord,
And what happened to Abdul Kalam?
No, Abdul Kalam has been arrested, my lord, and he's in judicial custody, my lord.
Okay.
Accused number 3, my lord.
And Tazmul is missing.
Tazmul is missing, my lord. And they have, my lord, been in love affair with the informant also knows about it. And that's probably might be the also reason that the FIR has been lodged 8 to 9 days after the incident, my lord.
Yes.
Lordship,
Let him appear.
Lordship,
Because other co-accused, he is not the main accused. Other
Yes.
co-accused are on bail.
Lordship.
Heard Mr.
M. Burman, my lord.
M. Burman, learned counsel for the petitioner, also heard Ms. S.H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Tafiqul Haq, who is apprehending his arrest in connection with Sipajhar PS case number 319/2023 under section 366 of the Indian Penal Code. The gist of accusation in this case is that on 1st of October 2023, one Muhammad Mokibur Rahman had lodged an FIR before the in charge of Burha Police Outpost under which police station?
Sipajhar.
Sipajhar Police Station, inter alia, alleging that on 22/9/2023, the daughter of the first informant, who is about 16 years of age, went to her tuition class, and since then she has been missing. And later on, it was informed to the later on the informant came to know that the accused persons named in the FIR within bracket 6 numbers of accused are named in the FIR, took away the daughter of the first informant in a white color Maruti car and had confined her somewhere. Learned counsel for the petitioner has submitted that the allegation leveled against the present petitioner in the FIR is not true. It is further submitted by learned counsel for the petitioner that in fact the Tazmul is your younger brother or elder? In fact, the younger brother of the present petitioner, namely Tazmul Haq, was having a love affair with the daughter of the first informant, and both the younger brother of the present petitioner and the daughter of the first informant had eloped away, and their whereabouts are not known to the family members. It is further submitted that by the learned counsel for the petitioner that though the incident had occurred on 22/9/2023, however, the FIR was lodged after the delay of about 9 days. And this is due to the fact that the informant was also knowing about the love affair between the younger brother of the present petitioner and the victim girl. Learned counsel for the petitioner has further submitted that in the meanwhile, the accused number 3 named in the FIR, namely Muhammad Abdul Kalam, has already been arrested and he is detained behind the bar, whereas other 2 accused persons, namely Liaquat Ali and Rakibul Jaman, were granted interim anticipatory bail by this court in AB number 3512/2023. It is further submitted that the petitioner is apprehending his arrest as police is searching him and he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that the perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence, call for the case diary fixing
On 15th.
15/12 for the case diary. However, in the meanwhile, as 2 of the co-accused are already released on bail and as already on interim bail, and as it appears from the submission made by learned counsel for the petitioner that it is the younger brother of the present petitioner who was having a love affair with the victim girl and who has eloped with the victim girl, the custodial detention of the present petitioner does not appear to be necessary. No, this line is not necessary. The present petitioner is hereby directed to appear before the investigating officer. Present petitioner, namely Tafiqul Haq, is hereby directed to appear before the investigating officer of Sipajhar PS case number 319/23 within a period of 10 days from the date of this order and cooperate in investigation with the investigating officer. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Sipajhar PS case number 319/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to condition that the petitioner shall cooperate in the investigation. Let this case be again fixed on 15/12 for Kerala.
Same order for 42, madam.
No, in 14/12, heard Mr. A.Z. Hussain.
No, madam. M. Burman, madam.
Heard Mr. M. Burman, learned counsel for the petitioners. Also heard Ms. S.H. Gora, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on 15/12. The interim order shall continue.
Much obliged.
Obliged.
I'm taking 2 minutes break.
My reason. In here, the petitioner filed a Zimmer petition before the court below for releasing.
A report would be required from the IO.
In here, the petitioner filed a Zimmer petition for releasing his vehicle, which was his in connection with Sonapur PS case here. And the court below passed the order that is at page 26 here. And the relevant portion is at page 29. The prayer of the petitioner was
Why it was rejected?
on the ground of gravity of offense.
And the objection submitted by the IO.
And thereafter, the petitioner filed a revision petition before the Honorable High Court. And the petitioner was directed, that is at page 31 here.
Oh, that is a review order.
And the matter was remanded back to the court below. Herein, the petitioner is directed to approach the trial court along with the relevant documents like registration card in support of the ownership of the vehicle. And the trial court may pass an order on Zimmer as per merit of the case.
Where is the order of the High Court?
And that order is paid 33 years.
33.
33.
No, 33 is the order of the
29 is the order of,
Initial order is at 29 years.
this is by CJM, no?
Initial
Additional
order is
session
that.
judge.
And after remanding back the matter to the trial court, your lordship, that order is paid case 33.
you are challenging this order.
Yes.
27/9/23.
That order as well as the order passed on 27/9/2008. Case 33.
No, you are challenging
Yes.
27/9 only.
Yes, yes. Case 33 years.
For that, records could be required.
No, in fact, a report from the police officer, I think will do.
Case diary.
Not the case diary, a report. Because in the earlier order, it is said that he couldn't produce the orders, the certificates owning the ownership, the documents. So he could not submit those documents regarding the ownership. He's the owner. And confiscation proceeding is also there. But of course, Supreme Court judgments, there are so many Ambalal and all, saying that even in NDPS cases, the things can be given on Jimma, I mean, by taking proper bond and everything photographed.
But in this case, no confiscation proceeding has been initiated. And page 32.
Now, at what stage the case is pending? Whether investigation is over?
Investigation over, your lordship, now.
Charge sheet has been laid.
Now at evidence stage, your lordship.
No, why the IO has objected?
IO has objected. He did not give any reason. He said, gravity of offense cannot be a ground. And objection submitted. Let me get a report from the IO then. Otherwise,
What? Yes, 32, your lordship. This report was, your lordship, submitted by the IO before the court below, your lordship. It's 32. Herein, he has objected on the ground that the seized article is a prime evidence in connection with the above reference case. If the seized truck may be given in Zimmer on its registered owner, he may modify the structure of the truck, which may hamper the case. This is the ground, your lordship, mentioned by the IO. And this report was placed before the court below, your lordship.
No, how do we know that court relied on this report or some other?
We have obtained this from the court, your lordship. I have the certificate copy, original certificate copy.
32.
32.
Page number 32.
The original copy of this order, this report is with me.
This may not be a valid.
Transporting a huge amount of The owner of the seized vehicle has not appeared before the IO for claiming his ownership. Furthermore, the owner for examination. That's
What
why
was the allegation? The-
Allegation is your
What
lordship.
was found?
it was found in the truck, and the truck had few chambers in the driver's seat. And
Case 17, your lordship. That's right. Earbuds tablet was required, your lordship.
Later, you
the report from the IO of final, then lordship will decide on that day itself. A short date, it is Kamrup only.
heard Mr. A.M. Khan. Heard Mr. What is your name?
A.M. Khan.
A.M. Khan, learned counsel for the petitioner. Also heard Miss S. Jahan, learned additional public prosecutor. This application under section 401/397 of the Code of Criminal Procedure, 1973, read with section 482 of the said code, has been filed by the petitioner Ilyas Khan, impugning the order dated 27/9/2023, passed by learned, who passed this learned additional session judge within the PC number 3, Kamrup Metro, Guwahati, in NDPS case number 150/2022, whereby the Jimma prayer of the present petitioner seeking Jimma of the seized vehicle, that is a truck bearing registration number MN019937, was rejected. Learned additional public prosecutor submits that he may be allowed to obtain a report from investigating officer of the case. You will obtain report from IO.
IO of the case,
Whether
29th of November.
whether IO will be still in touch with this case, because it has been a charge sheeted case. IO may not be having any material apart from the copy of the case diary would be in the court.
Case diary will only be then the option. But again, whether it is at all required, if it is charge sheeted, then it's not required for any further investigation.
No.
Case is charge sheeted here.
What was? Then it is not required. Then we will impose conditions.
Lordship, and give the Jimma.
No,
I didn't know that.
Where is the vehicle?
Right now, here lordship police station.
Oh, then it is in the police station. You seek a report from the officer in charge of the /IO.
Yes, sir.
Considering the submission made by learned counsel, learned additional prosecutor, the prayer is allowed. The additional public prosecutor may seek a report before next date from the concerned investigating officer / officer in charge of the police station, either OC or I, regarding the necessity of retaining the vehicle bearing registration number MN01N9937 in connection with the pending trial in NDPS case number 150/2022. Let this case be listed again on
Kamrup, sir, 29th November, I'll get it by telephonic instruction.
29
As motion item here.
in admission as the motion.
In motion.
Today it was in motion.
Since it is
Okay, let this case be listed again. Motion copy.
On 29th.
Obliged.
So is the not a power.
Okay, 14.
Will not be at- but
Time being we have to do.
My lord, FIR is my lord 9, my lord. 11%, my lord. 13.
Since when you are detained before the court?
My lord, from my lord, around 2 days, 63 days, my lord. 17/9/23. Arrested on 17/9/23.
My lord, 392 lordship punishment, which may be extended up to 10 years lordship. It will come among another 60 days of
60 days.
60 days of it.
My lord,
So he has already
Completed. lordship.
completed it. Why are you?
my lord, on last occasion, my lord, my associate submitted, but already our my lord has it.
Heard, Mr. What is your name?
M. Hussain.
M. Hussain, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor, who has produced the case diary of the Bayhata Sareli PS case number 257/2023, which was called for in connection with this. The accusation in this case is that on 29/8/2023, one Nippon Samoa lodged an FIR before the officer in charge of Bayhata Sareli police station, alleging that when that two boys had snatched 2 numbers of mobile phone from him and fled away. Whether materials are there again?
The materials are there, but it was the investigating officer could not recover it because they sold it the mobile phone.
So, the case was registered under, on receipt of the FIR, the Bayhata Sareli PS case number 257/23 was registered under section 392/34 of the indictment. So, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar since 17/9/2023 and has already been detained for last 66 days, whereas the offense under which this case has been registered, that is 392 of the Indian Penal Code, prescribes maximum punishment for 10 years. You have verified it?
Yes, yes, lord, I verified it.
For
Extended up to 10 years. lordship.
up to 10 years.
If it is my lord, during sunset and sunrise, then it will be 14 years.
10 years. And therefore, as per section 167 clause 2 of the Code of Criminal Procedure, maximum statutory period of the detention in this case is only 60 days, which has already lapsed. Considering the facts of this case, the petitioner Abu Firdaus Razi alias Rahul is hereby allowed to go on bail of rupees 30,000 with one security of like amount, subject to the satisfaction of learned Chief Judicial Magistrate or SDGM Rongia. Which is the court?
Rongia, madam. SDGM Rongia.
Learned SDGM M Rongia. With above observation, this bail application is granted. Yes.
Twenty-seven.
I have 27.
Next item we will call.
Which is solicited case, 489 ACND, whatever fake currency lordship.
Lordship, scan copy of CD was called for that we have not received.
Lordship, he is already in custody lordship, 140 days lordship. Already solicited is annexed with the petition lordship. And another, other case, 4 cases has been granted bail lordship.
How many accused were there?
3 lordship. From me lordship, no machines, nothing has been recovered lordship.
When your
Lordship.
When your prayer was rejected by the trial court?
Lordship, page number lordship.
Fake currency. With 10 people.
37 lordship. On 510.
On what ground it was rejected?
So it was recorded that there is a primary facie material has been found. Also, from me, only the fake currency has been recovered. And even it is assumed that from me, currency, then it will affect only 489C, which is a bailable offense lordship. 489C will come into play lordship. Other than that, lordship, nothing has been recovered from me. No machine, nothing lordship. And one who has given supplied to me the currency, he has already been granted bail.
Where is the order?
By the honorable court. 140 days.
The matter has been surseated, Lordship.
When he was granted bail?
Another court is
Yes.
9/11.
Now, whether charges are framed against you on the
But
same,
no witness has been examined
same date.
till now. So nothing has been recovered. I'm on
On the ground of parity,
Lordship.
because co-accused has been granted
Lordship.
bail, who stands on same footing.
Lordship.
So let him also
No.
cooperate,
May be recorded because.
cooperate in
Yes.
trial.
Yes.
Heard Mr.
D.
Kolita, learned counsel for the petitioner, also heard Ms. S.H. Vora, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed, Criminal Procedure, 1973, has been filed by the petitioner Muhammad Shahanur Islam,
Shahanur.
who has been detained behind the bar since 5/7/2023 within bracket since last 140 days. 140 days, yeah,
139 days.
139 days. I am mentioning it in the order based on your submission. I am not calculating. 139 days in connection with sessions
Case number was
case
138.
number 138/2023
2023.
pending before the Court of Learned Additional Session
Number 2.
Additional Session Judge FTC number 2, Kamrup Metro Guwahati. Learned Counsel for the petitioner has submitted that the petitioner has submitted that the petitioner is facing trial before the Court of Learned Additional Session Judge number 2 in connection with Sessions Case number 138/23, wherein charges against the present petitioner has been framed on 1/9/2023 under section 120B/498A/498C of the Indian Penal Code. It is further against how many accused?
Three.
Along with other 2 accused persons. Both the accused were released or one of them?
One and another is left.
Another
main accused from whom machines and all were recovered.
Learned Counsel for the petitioner has submitted that the petitioner has one of the co-accused, namely Muhammad Bulbul Alam, who is also facing the trial in connection with the same case and stands on same footing as that of the present petitioner, has already been granted bail by this court in bail application number 3192/2023 by order dated 10/11/2023. And it is submitted by the Learned Counsel for the petitioner that the petitioner is ready to face trial, and on the ground of parity also he is entitled to get bail. Stop. On the other hand, Learned Counsel for the Learned Additional Public Prosecutor submits that though the scanned copy of the case record was called for, however, same has not arrived. Stop. And prays for another date for producing the same. Stop. Considering the fact that the petitioner has been detained behind the bar since last 139 days.
138 days as per my calculation.
138 days, make it
Yes.
130. 138 days. And also considering the fact that one of the co-accused, namely Muhammad Bulbul Alam, who is similarly situated to that of, similarly placed to that of present petitioner, has already been granted bail by this court, this court does not find it necessary. No, this court does not find further custodial detention of the present petitioner to be necessary for fair completion of the trial if he cooperates in the trial of Sessions Case number 138/2023. In view of above, the above named the petitioner, namely Muhammad Shahanur Islam, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject amount to the satisfaction of Learned Additional Session Judge within bracket FTC Number 2, Kamrup Metro Guwahati with following conditions. Number 1, the petitioner shall appear before the learned trial court as and when so required by the learned trial court, and he shall cooperate in his trial. Number 2, the learned trial court may impose any additional condition or bail if it deems fit to do so. With above observation, this bail application is hereby disposed of.
Highly obliged. My lord, in this case, the petitioner is custody in 11/9, 71 days as on 2 days.
LCR call for lordship that has been received.
And
As per the order dated 3/11/2023, the case is pending in the stage of consideration of charges. Lastly, it was posted on 14/11 for consideration of charges.
petitioner, what happened, my lord? Petitioner appeared before the court below and he was taken into custody on 11/9. So since the case is succeeded and one quake was granted anticipated bail by this noble court. And at the same time, my bail application was rejected. So thereafter,
Who is the main accused?
petition number 1, that petitioner.
You are not the. What
They
is-
say I am the petitioner, my lord. I am the
Not he is
prime
the main
accused, my lord.
accused.
People also kindly see the FIR. Very page 11 is the FIR, my lord. No date when the offense has been committed. They say since 4 months there he is raping her, and there is some discussion for amicable settlement, and thereafter lost the FIR, my lord.
What is your name? Mizanur.
Mizanur.
Janur Rahman.
The allegation is against you only.
Yes.
Yes, lordship.
And say help of his brother-in-law. Absolutely false allegations, my lord. I am a
This is-
student. I am a student, my lord. I went there on that day to visit my brother-in-law's house. Only one night I spent there. Thereafter I returned back. I am a student of studying at Bangagor College, my lord. Then, my lord, after getting summoned, we appear, my lord. The Lakshmi is a page, Padar is page. And as a
Why
first
after
lecture-
getting summoned,
My
you
lord.
were shown as absconder in the charge?
Because I am nothing new about the case, my lord. Thereafter I produced this novel book for anticipated bail.
He is the prime accused.
Yeah, correct. Thereafter I appear before this noble court. I come to this noble court. Since bail has been rejected, I appear. I appear, my lord. I am not aware about the case, my lord.
Now I'm
After,
objecting at this stage.
let me complete. Then, my lord, what happened, my lord? When I came to learn about the case, I immediately filed a disputed bail application along with the quake. The bail of quake has been allowed, but at the same time, my bail has been rejected. So thereafter, I appeared before the court below, and court below taken me on custody. After all, my lord, trial is going on, but no charge has been framed, no copy has been served. So, my lord, there will be a long procedure. So, since I am a student, my lord, so if I consider the length of detention, I may be allowed to go. I will cooperate, my lord. Every day I will appear, my lord. Maybe there is some offense, there may not be, my lord. Because as per FIR, there is no involvement, my lord. He say after since 4 months, he raped her. There's no date, nothing has been mentioned. And they say that one day they visit the house of the parents of the petitioner on 5/12/2021. And no amicable settlement has been arrived. Thereafter they lost this FIR. So, by considering any condition, well, I am a student, my lord. My
Yes.
Lordship, the trial proceeding is yet to be initiated. The very nascent stage of trial proceeding. Charges are yet to be framed. And
So any
vital
condition-
witnesses are yet to be examined.
But there is a delay in lodging FIR, that is 4 months delay.
Lordship. But at least, Lordship, the informant gets later be examined, plus Lordship thereafter, Lordship, we consider.
What you apprehend that he may threaten the
He may, if there is every chances of hampering and tempering the evidences as well as witnesses.
I will.
So Lordship,
I'll give
kindly my
undertaking.
objection, I'm objecting right at this moment.
I will get an undertaking.
heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner, namely Mizanur Rahman, who is 21 years of age, and who has been detained behind the bar since 11/9/2023, within brackets since last 71 days in connection with Sessions case number 65/2023. Learned counsel for the petitioner has submitted that the charge sheet in Sessions case number 60 in PRC case number 105/25 was laid on the basis of an investigation which was initiated after lodging of an FIR by one Manwar Hussain on 19/12/2021, whereby it has been alleged that about 4 months prior to lodging of the FIR, the present petitioner had forcefully raped the sister of the present petitioner with the help of his brother-in-law, namely Shah Jahan Ali. Learned counsel for the petitioner submits that in the meanwhile, the co-accused, namely Shah Jahan Ali, has already been granted anticipatory bail by this court. It is further submitted by the learned counsel for the petitioner that the petition, where is the charge sheet? That the petitioner was shown as an absconder, that the present petitioner has been shown as an absconder in the FIR, in the charge sheet. However, and thereafter he received summons from the committal court, and after receiving the summons, the petitioner had appeared before the committal court, and on appearance before the committal court, the petitioner was remanded to custody and since then he is in custody. It is submitted by learned counsel for the petitioner that the petitioner is ready to face the trial and would cooperate in trial under any conditions which may be imposed by this court or the learned trial court. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner at this stage on the ground that the evidence, the trial is in its nascent stage and charges are yet to be framed. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the scanned copy of this sessions case number 65/2023. It appears that the charge sheet has been laid against two persons, namely the present petitioner and one Shahjahan Ali, and the other person has already been released on bail. Under such, it also appears that the FIR in this case has been lodged after a delay of 4 months. Under such circumstances, if the petitioner cooperates in his trial and abides by the conditions imposed on him, this court does not seem it necessary to keep the present petitioner under detention during the pendency of the trial, which is yet to be commenced. How many witnesses are?
Listed witnesses.
I am not.
8 witnesses, which is yet to be commenced. Considering the above, in view of above, the petitioner Mizanur Rahman is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned. Which court it is pending?
Session case number.
No, which
Session court.
which court?
Do you need to see lordship?
No.
It will be sessions.
Learned session judge,
Section just lordship.
learned session judge Ahmad is subject to following conditions. That the petitioner shall appear before the learned trial court as and when so required by the trial court for the sake of fair completion of the trial pending against the present petitioner in sessions case number 65/2023. The petitioner shall not directly or indirectly make any inducement, threat, or promise to the victim or to any person, any listed witnesses or any other person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts in the trial pending against the present petitioner. Number 3, the learned trial court may impose any additional condition if it thinks fit, if it deems fit to do so. With above observation, this bail application is thereby disclosed.
Lordship may
Hyderabad.
submit in a recent Supreme Court judgment, lordship. The law, the principle of parity is not an absolute law, but it depends on the circumstances and rules and areas granted. So,
That you have to submit before I dictate order.
lordship, just now I have received that.
Okay.
I'm obliged, lordship.
May I please, your lord. 439 application, my lord.
No,
82
but
days.
for refusing bail,
Not,
principle of parity may not be same, but for refusing bail, some ground has to be there.
yes, lord.
That this would be implication if he is allowed to go on bail. That implication would be considered. Otherwise, all UTPs shall have to be in jail.
Yes.
There has to be some grounds for refusing bail.
Lordship.
Yes, Mr. Vishal.
With all respect for it, always I pray that even the maximum judgment to apex court, they are given highest priority to Article 20. In connection with the bail.
But there are observation on other side also.
Yes, my lord, your lordship, I think hard. The first time in our country, a GPS has been implemented upon a under-trial prisoner in Jammu and Kashmir.
Condition, one of the condition.
Yes.
Okay.
Then it is the problem. I am the only person in India who oppose and written letters to the editor. It has been published Son of the Daily. So how it is? It is violated to Article 21. Whatever right.
Okay.
But of course, my matter is different. The 413 application matter. Here, my wife has lodged a affair that I have taken her forcefully in a car and engaged in a case of 376D. Well, the affair I take your lordship. Since last
There is there.
since last 3 months, she has left my house and deciding separately because of our difference of opinion. And thereafter, my lord, she has projected this case. But I take your lordship, the FIR page 11. Kindly please come to page 11, my lord.
Number 59, lordship, probably there is no case diary, lordship. I'm on interim there, lordship. Can it be some other day, lordship?
Okay. 59. Heard Mr. P. Chaudhary, Learned Counsel for also heard Mr. R.J. Borwa, additional prosecutor.
Yes.
Who prays for another date for producing the case diary. Prayer is allowed. Let this case be listed again on
412.
412.
Interim
order shall continue.
Highly obliged.
When is, in this case, when is the 90th day?
No, it will be 27, Lord.
When it should be fixed?
27.
Heard Mr. H.C. Biswas, Learned Counsel for the petitioner. Also heard Mr. R.J. Borwa, Learned Additional Public Prosecutor. Though the case diary is available, however, Learned Counsel for the petitioner has submitted that this case may be listed on 27th. 27.
No, 27 is a holiday, Lord.
28/11/2023. Prayer is allowed. Let this matter be listed on 28/11.
May it please your lordship. So the 439 application, my lord. The petitioner was arrested on, my lord, 25/9, my lord. 25/9, my lord. And, my lord, the allegations are, my lord,
302 is there.
304B is also there, my lord. The both cannot be attracted, my lord. Either one, there can be one allegation, my lord.
No, but there is a judgment of apex court that even in the case of framing charges, when there is 304B, alternative charges are to be framed under section 302.
But in the present context of the case, my lord, lordship may kindly see, my lord. And
what is your submission?
My submission.
How she died?
She committed suicide, my lord.
By hanging.
By hanging, my lord. You may kindly see when my bail was rejected, my lord. The second judge, my lord. What, my lord, he has, my lord, page 17 is the order of the learned session judge, my lord. The relevant portion is page number 18, my lord. Page 17 is the submissions of the advocates, my lord. Page 18, my lord. I have perused the statement of the witnesses recorded under section 161. None of the witnesses have categorically stated that they had seen the accused person killing the victim, though the family members of the victim have stated that the accused person used to torture the victim. It is relevant to mention herein that no particular or instances were quoted by the state witnesses of alleged tortures.
Then why it was rejected?
My lord.
Oh, co-accused are allowed to go on bail.
My lord, co-accused family members and mine was rejected, my lord.
Your husband.
Husband, my lord.
What is the,
Whether further custody 68, 58 days.
Lordship, here Lordship, postmortem report is required of it because it is there, but to ascertain the cause of death, we need the FSL report that is awaited. Lordship. Because cause of death, that is a prime issue at this matter. Lordship. How she died, whether it is suicidal or hanging by herself, hanging by the petition.
no, otherwise postmortem report suggests that ligature marks,
Yes,
whether it suggests hanging,
Lordship.
though
that-
final report is pending.
Yes, the cause of death should not be ascertained, Lordship, otherwise, because of the pending of FSL report and
FSL report for what purpose?
Lordship,
Whether poison has been administered or
no, yes, Lordship.
Poison of
How she died, like whether strangulations is there or
strangulation.
no
The-
such mark, Lordship. Nothing is come out from the report, Lordship.
There is no,
Otherwise, Lordship, mark of ligature neck that is there.
only mark of ligature is there.
Yes, a non-continuous ligature mark of size, so it's 25 cm into 3 cm.
Non-continuous.
Yes. That is
non-continuous is special lordship knows manner and 58 days in custody manner. Whether my further custody is required.
Yes, that's correct.
Lordship, but this is objecting the bail period because we need the FSL report. The cause of death is yet to be ascertained.
When the ligature mark.
No, what FSL report would say?
Lordship, how whether she has been administered poison.
Poison. Now, is there any allegation that she has been administered?
That is, Lordship, that is not there, but otherwise, Lordship,
There is no
the
allegation in
allegation
the
is.
FIR manner. There is no.
Is
Lordship,
there
kindly
any,
come to the FIR, Lordship. Only
Poison of
all the accused persons has confined her in a room and killed her by wrapping a cloth around her neck and hanging her body in a ceiling.
no
fan.
allegation of poison.
strangulation?
Yes,
The allegation is of,
strangulation,
but postmortem report does not suggest.
Lordship.
Otherwise also, where,
Lordship,
what is the other progress of the investigation? Recording of testimony of statement of witnesses.
Lordship.
No, for what purpose the investigation is pending?
Otherwise, there is no such direct
For
evidence.
For FSL report only.
Yes, Lordship, only for that.
So for that, whether his detention would be,
Lordship,
for that, whether his detention would be required.
I leave it to your Lordship, otherwise, FSL report from my opinion, it is required.
Heard Mr. S. M. Abdullah P. Learned Counsel for the petition. Also heard Ms. S. H. Bora, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Habibullah, who has been detained behind the bar since 25/9/2023, within bracket, since last
58 days.
Since last 58 days, in connection with Duliajan PS case number 236/2023 under section 498A/304B/302 of the Indian Penal Code. The gist of accusation against the present petitioner is that on 25/9/2023, one Musammad Meherun Nesa lodged an FIR before the officer in charge of Duliajan police station, inter alia, alleging that the daughter of the first informant was married to the present petitioner, and after the marriage, she was subjected to cruelty, both physical and mental. And And it is further alleged in the FIR that on 24/9/2023, the present petitioner, along with his brother and mother, as well as sister, confined the daughter of the first informant in a room and killed her by wrapping a cloth around her neck and thereafter hanged her to a ceiling fan. Learned counsel for the petitioner submits that. What is your submission?
Petitioner is behind the bars for 58 days, madam. And the
And regarding allegations?
allegations he has committed suicide, madam. He has committed suicide. It's a case of suicide, madam.
Learned counsel for the petitioner submits that the allegations leveled against the present petitioner in the FIR are not true. In fact, it is submitted that, in fact, the wife of the present petitioner had committed suicide. Stop. It is further submitted by learned counsel for the petitioner that the petitioner has been detained behind the bar since last 58 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Duliajan PS case number 236/2023 and has vehemently opposed the grant of bail to the present petitioner on the ground that though the post-mortem examination report is available, however, the cause of death could not be ascertained and it is kept pending after receipt of it is kept pending, and the viscera of the dead body has been sent to post FSL forensic laboratory for examination as to whether any poison has been administered or not.
And moreover, Lordship, just prior to the occurrence, he has been persecuted both mentally and physically by the family members.
It is also submitted by learned counsel for the learned additional public prosecutor that there is evidence on record to suggest that there is material on record to suggest that the petitioner was subjected to cruelty before the alleged offense. I have considered the submissions made by learned counsel for both the sides and have perused the materials in the case diary. It appears that the post-mortem examination report reveals that it appears from post-mortem examination report that though the final opinion on the cause of death has been kept pending, however, it reveals from the said report that the non-continuous ligature marks were found on the dead body of the wife of the present petitioner, which suggests that she had committed suicide. There is no other indication to suggest that other physical injuries are there.
Lordship, that is not detected, Lordship.
Other physical injuries are not detected on the dead body of the deceased during post-mortem examination report. Further, what happened to other co-accused?
They were released on bail by the learned session judge, madam.
Further, considering the fact that other co-accused persons are already released on bail and the petitioner has been detained behind the bar since last 58 days, this court is of considered opinion that further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of Duliajan PS case number 236/23 if he cooperates in the investigation. Stop. In view of above, the petitioner Habibullah is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate Dibrugarh with following condition that he shall cooperate in the investigation and shall appear before the investigating officer as and when so required for the sake of fair completion of the investigation, that he shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the investigating officer. This bail application is accordingly disposed of, sent back to case.
Obligement.
Obliged, Lordship.
Mayor, please. Hereby the petitioner may complete 90 days taken today, madam. Offense is under section 302, madam. You are the arrest on 23/8, madam.
Only 90 days? Oh. Okay.
What is
And
the offense?
otherwise also it's like burning, she died out of burn injuries.
Only on suspicion.
And yes, of course, and the son is a witness. Son had stated he is a 10-year-old boy.
Otherwise 90 days.
Otherwise also 90 days, and case record also doesn't show. Of course, the neighbors have seen both of them sleeping together. She with burn injuries, and they were not taking her for treatment. Rather, they were putting some oil and all inside home. Otherwise, also 90 days. Son has not implicated the father.
Okay. Third, Mr. S. Bhattakur, learned counsel for the petitioner. Also, it is exactly 90 days.
Yes.
He has calculated 8 days in August. And September, it's 30, 31, and 21.
This application under section 439 of the Code of Criminal Procedure, 93, has been filed by the petitioner Baschu Das, who has been detained behind the bar since 23/8/23. 23/8/23. Within bracket, since last how many days? 90. Since
He is
last,
arrested, yes,
since last 90 days,
23rd.
in connection with Moranhat PS case number 49/23 under section 302 IPC.
That's why not.
Learned additional public prosecutor has produced the case diary of the Moranhat PS case number 49/23 and has submitted that though there are some materials against the present petitioner in the case diary, however, the son of the petitioner, who was also present inside the house when the incident
At the time of the occurrence.
at the time of the
What he
occurrence,
said that I was taken outside and then mother went inside, locked the door, and she burnt herself.
and has not implicated the present petitioner. In otherwise also, it is submitted by learned additional public prosecutor that today is the 90th day of detention of the present petitioner, and the statutory period of detention in this case is 90 days under section 167 clause 2 of the Code of Criminal Procedure. In view of the fact that the petitioner has completed the statutory period of detention under section 167 clause 2 of the Code of Criminal Procedure, he is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Dibrugarh.
Soraido, madam.
Soraido. Chief Judicial Magistrate Soraido. With above observation, this bail application thereby is sent back against.
Obliged.
May I please Lordship, but 439 application letter. Proceeded case, my.
Since when you are behind the bar?
My lord, 12/8/2023.
How many days?
102 days. My lord, the case initially FIR was filed, my lord, 302, my lord.
Okay.
But case police prosecuted the case under section 120B, 379 and 304 IPC. My lord, charge sheet has been filed against 3 accused persons, my lord. 2 are in the jail, my lord. 1 is absconding. Case is pending before additional CGM Barpeta, my lord.
Then why trial court has refused your bail?
Refused, my lord.
Why? Where is the
rejected
rejection order?
case 32, my lord. Type to be. After filing the charge sheet, my lord, the petitioner approached on a trial court.
No, because what is your name? Asiruddin.
I know Hawk, my lord.
I know.
Cognizance taken, my lord. Someone issued to the absconder accused Asiruddin. Kindly see the page 31, my lord, another order of additional CGM. 31, my lord. Below 4 line, my lord. Asiruddin is showing absconder in the charge sheet, issue summons to the accused person. Here, my lord, 3-4 days already gone, my lord. The absconder accused person not appearing, my lord. Therefore, the petitioner is laying in the jail, my lord. 102 days, my lord, behind the bar. Case is not committed, my lord, because it is a questionable case pending in the additional CGM, my lord. Until and unless the accused absconder accused is not appearing, case will not commit, my lord. Therefore, problem.
Uh,
M. Islam, my lord.
Mr. M. Islam, Learned Counsel, let him cooperate.
Yes, sir. Any condition, term.
Heard Mr. M. Islam. M. Islam, Learned Counsel for the petitioner. Also heard Ms. S.H. Bora, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1953, has been filed by the petitioner Ainul Haq, who has been detained behind the bar since 12/8/2023, within brackets since last 102 days, in connection with PRC case number 2565/2023, arising out of Sorghum PS case number 43/2023. Learned Counsel for the petitioner has submitted that though after the Sorghum PS case number 43/23 was registered on filing of the FIR. Where is the FIR?
FIR is Panagola 14 meter. 14.
On filing of an FIR by one Birkang Brahma on 19/3/2023 under section 302 of the Indian Penal Code. However, after completion of the investigation, charge sheet was laid against the present petitioner and how many accused?
3 accused.
And 3 other co-accused under section 120B/379/304 of the Indian Penal Code. It is further submitted by the petitioner that though the petitioner has been detained behind the bar since last 12/8/2023 and the case has been pending before the Learned Committal Court since last 22/9/2023, the case could not be committed to the Court of Sessions due to absence of one of the co-accused, namely Asiruddin, who has been shown as an absconder in the charge sheet. Learned counsel for the petitioner has submitted that the petitioner is a permanent resident of village Kolabanda under Kosumara police station under the jurisdiction of the court of under the jurisdiction of the committal court where the PRC case number 2565 is pending, and he is ready to cooperate in the trial. What is your submission you have?
Lordship, now the case is pending in the stage of production. Charges are yet to be framed.
Opposing.
Yes.
Learned additional public prosecutor, on the other hand, has opposed the grant of bail to the present petitioner on the ground that the case is yet to be committed to the trial court, and trial is yet to be commenced, and one of the co-accused is yet to appear before the learned committal court. So I have considered submissions made by learned counsel for both the sides and peruse the scanned copy of the case record of PRC case number 2565 2023. It appears that the petitioner has been detained behind the bar since last 102 days. It also appears that the case pending before the committal court has not been progressing due to non-appearance of the co-accused, who has been shown as an absconder in the charge sheet. This court finds no justification to continue the detention of the present petitioner only for the default of the co-accused, who has been shown as the absconder in the charge sheet, if he otherwise cooperates in the trial. In view of above, the petitioner, namely Ainul Haq, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned additional Chief Judicial Magistrate Borpeta, with a condition that he shall appear before the committal court as well as trial court as and when so required by the said courts, and he shall not directly or indirectly make any inducement, threat, or promise to the listed witness in the charge sheet or to any other person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the court during the trial. With above observation, the bail application is hereby disclosed.
Okay.
Is hereby-
Okay.
May I please, your lordship? 438 application, lordship. We are on interim, lordship.
My lord, here is charge sheet submitted, my lord, as per information, my lord.
Whether you appeared before the
Yes, lordship. We all appeared good. I
heard Mr.
actually.
S. Ali, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional prosecutor. Learned counsel for the petitioner has submitted that by order dated 10/4/2023, the petitioners were allowed to go on interim anticipatory bail.
Lordship, another order is there. 22.
The petitioner number 6 was 6, that is Anwar Ali, was allowed to go on bail of interim bail by this court. Similarly, and prior to that, by order dated 22/3/2023, the other petitioners, all other,
Yes, Lord.
all other petitioners were allowed to go on interim bail by this court. And it is submitted by learned counsel for the petitioners that in pursuant to the directions of this court, all the petitioners have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, however, in the meanwhile, charge sheet has been laid in this case, bearing charge sheet number.
114/23, dated 24/5/23.
Stop. In view of the laying of the charge sheet, as well as in view of the fact that it appears that the petitioners have cooperated in the investigation and have complied with the directions of this court, the interim anticipatory bail granted to the petitioners by order dated 22/3/23 and 10/4/2023 respectively is hereby made absolute with the conditions number 3, 4, and 5. Condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is hereby disposed. Send back. Disposed of.
Well, deeply obliged. My lord, here CD was called for, my lord. They are in interim, my lord. CD not received, my lord.
Heard Mr.
R. Islam.
R. Islam, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on
5/12, man.
5/12 for the case diary. Interim shall continue till next day.
Obliged.
My lord, here is also a similar prayer, my lord. It was sent for up-to-date, my lord, and not received the up-to-date CD, my lord. They are in interim, my lord. Up-to-date CD.
Petitioner already appeared before the IO, my lord, and recorded.
Heard Mr. A. M. Ahmed. What is the matter?
Matter is, my lord, relating to some misappropriation of the rights of the society, my lord. In fact, my lord, in this case, my lord.
Okay, let's see the.
My lord, up-to-date CD, my lord.
Heard Mr.
A.
M. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary. Prayer is allowed. Let this matter be listed again on
15, my lord. 15/12.
15/12 for the case. The interim order shall continue till next day.
My lord.
My lord, in petitioner or interim, earlier, my lord, this is rejected case, my lord.
My lord, here we have received the case diary, but my lord, here the present application of the petitioner was rejected by the court, my lord. Lordship may peruse at page 22 of their petition, my lord. By page 22, my lord.
Page 22 of the
Petition, my lord.
That is,
yes.
My lord, it was rejected by the lordship, my lord. Then it will go to the appropriate bench, my lord.
No, but the petitioners are on interim bail.
yes, interim granted by another court.
Interim granted by the later on.
No, they are after filing it.
My lord, they are interim, my lord, but it was earlier rejected by this court, my lord.
Yes, but interim order is there, my lord. Yeah, my court.
Okay, so it has to
Go to the appropriate bench.
same court.
My lord.
Rejected the other.
My lord.
Sorry, interim order was granted by another court, my lord.
Okay, but there is
My
an
That is there, ma.
appropriate bench.
heard Mr.
I.A.
I. A. Hajorika. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary is available, however, it appears from record that the prayer for anticipatory bail of the present petitioners
Earlier rejected.
was earlier rejected by a coordinate bench of this court. And it is submitted by learned counsel that this bail application should be considered by the same court as per the prevailing high court rules. Accordingly, let this case be listed before appropriate bench. You need a fixed date.
Also, in this case, for two cases, there is one fault. One is the first case, because the first case also, whether that is they have, I think.
My lord, here, my lord, two cities call for my lord, Nagaon PS 69 of 23 and 70 of 23. We have received 69, my lord.
No, let it go to the.
My lord, and the court, my lord, then they
Let that-
submit there.
We are fixing
My
it,
lord.
we are fixing a date.
My lord.
Called by the- Already order is followed, then it's calling up statement.
No, but it shows that you have otherwise cooperated in this case diary. In this case, they have appeared.
No, my lord, I have
After,
not.
after interviewing, they have appeared. Yeah, they have already
This
appeared.
case diary would show that whether they have appeared or not.
My lord, and then I will have to go through this, my lord.
You go through
my-
it before appropriate bench.
My lord, that is, my lord, that is.
Let this case be listed before appropriate
My
bench
lord.
by the registry on next week.
On next
Next.
Friday, it can be in
No.
Friday.
No, next week.
Next week.
Next week on fourth.
Let the registry
Registry
decide
decide.
whenever the
Okay.
bench's availability of
My
benches
lord.
Bench is there, I am told. On fourth.
on 4th of December.
My-
Perhaps.
My lord, CD not received, my lord, they are in interim, my lord. They are gone.
Heard Mr. A.R. Bhuya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case date. Prayer is allowed.
14, my lord.
Let this case be listed on 14th Feb. The
Right.
interim order shall continue till next day.
Obliged.
May please, your lordship. This is a 38 application, my lord. CG was called. I have appeared before the IO, my lord, before my statement.
My lord, CD received, my lord. After interim, he has appeared. Statement recorded.
Heard Mr. T.K. Bhuya, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated
Rana cycle.
3, 10.
3/10/23, the petitioner was allowed to go on. Petitioner Rana Soikia was allowed to go on interim bail, interim anticipatory bail by this court. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Lalu PS case number 177/23 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 of the Code of Criminal Procedure, 1973 has already been recorded. Stop. Considering the fact that the petitioner has cooperated in the investigation and has complied with the directions of this court, the interim anticipatory bail granted to the present petitioner by order dated 3/10/2023 is hereby made absent.
Deeply obliged.
My lord.
This case is accordingly disposed of, sent back the case.
My lord.
Obliged.
May please, your lordship.
My lord, here also we have not received case there, my lord. They are in interim, my lord. I prefer sometime, my lord.
Third, Mr. S. Jet Sheikh, learned counsel for the petitioners. Also heard Mr. B. Sharma, who prays for another date for producing the case diary. Prayer is allowed. Let the case be fixed again.
14th year.
Interim may be continued.
The interim order shall continue till next day.
Hello.
If I may please your lordship, this is a charge sheet matter, and the lower court records have been called for your lordship. The principal accused is on bail, and we are also willing to appear before the trial court, your lordship, and submit before the trial court. We're just looking for interim, if your lordship may kind help.
Well, in the last occasion, lordship was pleased to call for a scan copy of
Indeed, your lordship. Scan copies were called for, but
It was
they
not
have been
received, my
yet, your lordship. It has been around 40 days.
When is the next date fixed?
Next date fixed in the lower court is 20 of December. Your lordship.
Why are you not appearing yourself before the charge sheeted case?
Yes, your lordship, it's a charge sheet matter, and we are apprehending arrest if we appear before the what is the learned trial court, and therefore
No,
we are looking for
whether summons have been issued or
no,
warrant
your lordship, summons have not been. Summons have been issued. We received the summons in the month of June, your lordship.
thereafter.
Thereafter, we have apprehension that we might be arrested, and
Why?
therefore
Why?
your lordship, as per inspections, they have apprehension that they.
No, there has to be some basis for.
For why there is
If
a
Your
someone-
lordship, in the charge sheet, I have been mentioned as an absconder.
Okay.
Only word has been used against me as absconder. No material has been recovered. Nothing has been recovered from my possession also. And I am a friend of the chief accused who has been granted bail. And the only material against me is that my name comes with an absconder in the charge sheet. Your lordship.
But the offense are such,
Is triable by the sessions court. Maximum punishment is 10 years. Your lordship.
then you don't have any basis for apprehension. Then
Indeed,
the
your
trial court will grant you bail.
Your lordship, even if interim has been granted, we are ready to appear before the trial court, your lordship. Because there are instances where there have been arrests before, therefore we are not
No.
petitioner is not willing.
You must have some valid,
there is no
valid
apprehension why there is
ground for your apprehension. Mere apprehending that trial court will not grant bail.
Because of the
May not
absconder
be.
thing.
You appear before trial court.
We are willing to appear before the trial court, your lordship. On 20th December, the next date has been fixed, and we are very much willing to appear before the trial court. Just we are looking for an anticipatory bail.
No, this is not a case for anticipation.
It is charge sheet matter.
Though it is charge sheeted, anticipatory bail lies in a charge sheeted case also. But the basis for your apprehension is not genuine basis. You appear before the trial court and pray for regular bail there. With that observation, we may dispose it of. Or we
With that observation also it is.
heard Mr. T.A. Loskar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure 1973 has been filed by the petitioner Mohammad Moinuddin, who is apprehending his arrest in connection with Hojai PS case number 24/2015 under section 328/457/380 of the Indian Penal Code. What is the maximum punishment under
10 years.
328?
328, 10 years. Sessions payable 10 years.
Learned counsel for the petitioner has submitted that in the instant case, though the charge sheet has been laid, the present petitioner has been shown as an absconder in the charge sheet, along with one another co-accused, who has already been granted bail by the,
That we are unaware of.
who is already on bail. Stop. It is further submitted by learned counsel for the petitioner that as the present petitioner has been shown as an absconder in the charge sheet, he apprehends that he may not be allowed to go on bail if he appears before learned committal. Which court?
First, magistrate, trial by magistrate first. For JFM.
Which case is pending?
GR 2549/2000.
Before which court?
Before the CPM Hojai, Chief Judicial Magistrate Hojai.
By learned by the Court of Learned. Where is the order? No, where is the, any document to show that before which court is it is pending?
No, my lord, nothing, my lord.
Not have any document.
Only charge sheet here.
Then it may not be very.
My lord.
But
There.
that it can be relied upon the council. And that it GR 254.
Pending before which court? You verify it, then make
Hmm.
submit.
Statement of meeting.
Before which court it is pending?
Statement of tenant.
Before the Chief Judicial Magistrate Court. CPM, as part of the.
On what basis you are making that submission?
Yeah, this is for certified copy. In the certified. copy,
Pending before the court of learned. Learned Judicial Magistrate First Class. Mujay Shankar Dev Nagar. That is GR case number 2549 pending before the court of. On the other hand, learned additional public prosecutor submits that the submits that the scan copy of the case record of GR case number 2549 which was called for has not arrived.
No.
We are disposing it of. Stop. On a specific query posed by this court, learned counsel for the petitioner submits that as the maximum punishment under the offences under which the charge sheet has been laid,
320.
that is under section 328 of the IPC, is imprisonment of which may extend up to 10 years.
And fine.
And as the offense is punishable, is exclusively triable by the court of session, apprehends that he may not be allowed to go on bail if he appears before the learned committal court. You have received summons
In the month of June.
in pursuant to the summons issued by the said court. Stop. I have considered the submission. The apprehension shown by learned counsel for the petitioner does not appears to have any basis, as though the offense involved in this case contains a punishment which may extend up to 10 years, and though the offense charge sheeted, one of the offense against which charge sheet has been laid is exclusively triable by the court of embargo or bar on the part of the committal magistrate, that is judicial magistrate first class, to grant bail in such a case. Hence, this bail application is hereby disposed of with an observation that the petitioner may appear before the learned committal court and may pray for regular bail before that court, if so advised.
Right. What is the problem?
May I please, Lordship?
Lordship, city is called for. City received, my lord, along with the medical report, my lord. Offense is medical report, my lord, previous by sharp open.
Previous.
By sharp open. And witnesses are also available, my lord. Eyewitness, they have said that, my lord, Noga Dao, my lord, he assaulted in the, trying to assault in the, my lord, neck. Thereafter, it was in the ear, my lord.
In-
Not a case of, my lord, anticipated.
Yes, Mr. Fukon.
Well, he's not intended to cause such. No, there is
But it may not justify
my lord.
grant of anticipatory
My
bail. Heard Mr. B. Fukon, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned ready. You have any submission? No submission. If you don't make any submission, my job would be easier.
Lordship, actually. Nothing to submit, man.
Okay. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Pranab Sethia alias Baba Sethia alias Pranab Jyoti Sethia, who is apprehending his arrest in connection with Moranhat PS case number 50/2023 under section 294/324/307/506 of the Indian Penal Code. The accusation in this case is that on 1/9/2023, one Shri Krishna Barwa had lodged an FIR before the officer in charge of Moranhat Police Station, inter alia, alleging that the present petitioner had assaulted him after coming to his shop with a Naga dao and caused grievous injuries on his person, and thereafter also threatened to kill the associates as well as associates/colleagues of the first informant. Stop. Learned counsel for the petitioner has submitted that the petitioner is innocent. Stop. On the other hand, learned additional public prosecutor has produced the case diary of the Moranhat PS case number 50/2023 and has submitted that there are serious incriminating material against the present petitioners. The witnesses who have been examined have implicated the petitioner of assaulting the victim by a Naga dao. It is also submitted by learned additional public prosecutor that the medical report which is available in the case diary shows that the victim/informant sustained grievous injuries on his person, which is caused by a sharp weapon. Considering the nature of allegations and considering the nature of incriminating materials and the manner in which the offense has been alleged to have been committed by the present petitioner, this court is not inclined to grant the benefit of an order under section 438 of the Code of Criminal Procedure in favor of the present petitioner. In view of above, the present anticipatory bail application is thereby dismissed. Send back to case. Bail application is rejected.
May I update your lordship, my lord? Their petitioner was released on interim anticipatory bail on 27/10/2023, my lord. Thereafter, he appeared before the investigating officer, my lord, 3/11/2023, my lord. And case diary was called for, my lord.
Yes, ma'am. He appeared, my lord, his statement is recorded.
Let him cooperate.
Right.
Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that on 27/10/2023, the petitioner Shri Pankaj Mohan Yain was allowed to go on interim anticipatory bail by this court. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated with
On
the
3/11/2020.
on 3/11/2023 and has cooperated in the investigation. On the other hand, learned Mr. B. Sharma, learned additional public prosecutor, has produced the case diary of Dhemaji PS case number 149/23 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has also been recorded. Stop. Considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the present petitioner by order dated 27/10/2023 is hereby made and send back the case.
It's on disposal of my.
The anticipatory bail application is accordingly disposed of.
My lord, we have not received case diary today.
It will be probably a little bit tactic, probably. After taking interim order, my lord, this four petitioner, my lord, already appeared, my lord, and their statement is recorded. Here is the allegation, my lord, your lordship will find only 4-line paragraph allegation.
No, what, Mr. Sharma?
Case
Whether
diary-
case diary would be required.
My lord, as this, my lord submitted, my lord. If
Yes,
the
statement
statement is
has been
recorded, my
No,
lord.
what is the
My lord, FIR page A,
FIR?
director A. 307 has been just put only to make the case not big. Only 4-line, 8 director A, my lord.
No, let us, we have to see the case.
My, as he is, my lord, in interim, my
You
lord,
are
no,
on
no harm. my lord.
Heard Mr. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on
On my lord, 12/12, my lord.
12/12.
Well.
The interim order shall continue till next week.
Problem.
Okay. 59. Mention.
6069. Oh, Asif. Case
diary is there.
Yes, is there, my lord.
Lordship, in that case, can this matter kindly be taken up on Monday, your lordship, because Mr. S. Porter could appear in this, he's out of station. His leave note is also there.
Okay. Then on Monday, you come up with an instruction whether the petitioner has appeared before the IO with that instruction. Heard Mr.
S. Day, ma'am.
S. Day, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. S. Bhattakur, is out of station. On the other hand, Mr. B. Sharma, learned additional public prosecutor, submits that the case diary which was called for has been received. However, considering the submissions made by learned counsel for the petitioner, the prayer is allowed. Let this case be listed again on Monday.
Monday's holiday
1/12. 1/12. The case diary be retained till next day. Let the case diary be retained till next day.
There's an interim order that.
The interim order shall continue till next day.
Much of it.
Item number 61.
Make legal lordship. There's a 438 application, my lord. Fair, my lord, this page 9, my lord. Page 9 is basically, my lord, there is a allegation, my lord, 376, my lord. But which is totally false, my lord. Actually, what happened, my lord? They are their neighbors, my lord. And some rent was supposed to be paid to them, my lord. That rent was not paid, my lord, hence this FIR, my lord. In the FIR itself, it is revealed, my lord. There is allegation of pregnancy, my lord. Whether is there any medical evidence to prove that, my lord, that will reveal from the case diary? My lord, there is an allegation of miscarriage also, my lord. Whether there is anything to in the case diary, lordship may kindly see that, my lord. And lordship may kindly see, there is a allegation that we have not paid 35,000 from last 2 years. This is the main allegation, my lord. This is, we have not paid them. Whether there is any medical evidence to support my pregnancy or the miscarriage, my lord. And there is the allegation that we have not paid rent from last 2 years, 35,000 yearly, my lord, from last 2 years of the fishery.
Yeah. There are many accusations.
My lord, 164 C is implicated. 164, but he is a cousin brother of the my lord victim.
Then why there is a delay of 6 months?
My lord. And she is aged about 21 years.
But there is delay in lodging the FIR, my lord. In the FIR was lodged on 2/8.
The incident occurred on
February.
1st of April. Medical?
Medical, my lord, nothing has been, my lord, no evidence of recent sexual intercourse.
And the 376 is against whom?
Against this Ayub Ali.
Second
one.
accused.
Second.
The second accused, who is before this court?
Lordship,
my lord.
And what is your submission as regard allegation of the 376?
But 370 is totally false allegations, my lord, because there is a land dispute, my lord. She is my cousin sister, my lord. And my lord, only to my lord harass me, my lord, he has lost his FIR. But there were some disputes regarding the fishery also, my lord. My lord, some village meetings were also there. Whether she can prove that he has given any evidence of miscarriage regarding medical, and there will be nothing, my lord. She has revealed that she was pregnant also, my lord. Some her tablets were administered upon him. Her. So these are false allegations, my lord. And that too after 6 months, more than 6 months, in fact, but to an extent, my lord, that non-payment of rent, my lord, we may admit, my lord, my lord. 376, my lord.
Is there any material regarding pregnancy?
No, pregnancy, my lord, there is no such report.
What is your submission?
My submission, my lord, 164 says implicated, but although the incident occurred, my lord, since last 8 months, lord, so first, as per her 164 statement, third incident took place That was in the month of February. My lord,
Heard Mr. S. M. Abdullah P. Learned counsel for the petitioner. Also heard Mr. R. J. Burwa, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Ayub Ali, who is apprehending his arrest in connection with Ding PS case number 130/2023 under section 376 of the Indian Penal Code. The gist of accusation against the present petitioner is that who is the first informant?
Rupina Kakato.
No, she is not the victim.
Sister. My sister, man.
No, you have not translated it properly. I will go through the case and thereafter in chapter. If there are materials, it would be rejected, otherwise it would be.
Oh, Lord. Only that Lord may kindly see that whether pregnant is
Okay. And your submission is that she is defaulted in paying 35,000 rent for you.
There are some land disputes, they are my cousin sisters, mother. So there are some altercations, mother, regarding some dispensary rent, mother.
Okay, I'll go through the case.
And whether Lord may kindly see whether pregnancy, that administering tablets, whether these are true, mother. 164 statement, mother, she will reveal the what is the affair, mother.
Okay.
Oblige, mother.
Executive Lordship, case there is no receipt.
Disposed of. Taken the third. Heard, Mr. You are on interim? No.
No.
Case diary would be required. E95. Heard, Mr. R.
A. Chaudhary.
R. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who prays for another date for producing the case like that is allowed. Let this matter be listed again on
412.
412 for cases. 612 for case.
May I please, your lordship? Lordship, delegation under section 438. Lordship. Delegation is under section 341, 294, 326, 379. Lordship. On the lordship,
Well, we have received the case diary.
Injury report.
Here, injury report is simple, blunt, something. But allegation is against the present petitioner, my lord, Suleiman. Specific allegation regarding Suleiman. Some eyewitnesses are also there, my lord. They said that Suleiman assaulted the victim.
Heard Mr. Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioners, namely Suleiman alias Muhammad Suleiman Ahmed and Mansoor alias Mansoor Ahmed, who are apprehending their arrest in connection with Murajhar PS case number 223/23 under section 341/294/379/427/34 of the Indian Penal Code. The gist of accusation against the present petitioners is that on which date FIR was lodged? On 12/10/2023, one Mr. Anwar Hussain lodged an FIR before the officer in charge of Murajhar Police Station, inter alia, alleging that on 11/10/2023 at about 9:30 p.m., the elder brother of the first informant was assaulted by the petitioner number 1, assaulted by the accused persons named in the FIR, within bracket, the present petitioners. And they also took away 90,500 rupees and the bike belonging to the brother of the petitioner. What was the injury? Stitches were there?
No, my lord, there is, my lord. Lesser's pound of approximately 8 into 2 into 1 cm.
It is also alleged in the FIR that the injury sustained by the victim was grievous in nature and 8 stitches were put on the injuries. There is no sign of stitches in the injury report. However, learned counsel for the petitioner, what is your submission?
Lordship, they are the businessmen by having other business, Lordship. There is a business rivalry. 1 year ago, Lordship, the petitioner number 2 was assaulted by the informant family, Lordship. Thereafter, the petitioner number 2 lost an FIR with the Murada PS case, Lordship. Thereafter, the petitioner was not, the case was not registered, Lordship. Because the village elderly person enter into their matter and they are settle this matter amicably, Lordship. But the informant were not satisfied. They waiting for chance to take revenge on the day of arrest.
Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioners in the FIR are false. It is further submitted that the petitioners and the informant's family are business rivals. And about 1 year ago, an incident occurred where the petitioner's brother, who was injured,
Petitioner number 2.
petitioner number 2 was injured, and an FIR was lodged, however, same was not registered. And it is submitted that the present FIR has been lodged falsely only to harass the present petitioner. On the other hand, learned additional public prosecutor has produced the case diary of Murajhar PS case number 223/2023 and has submitted that there are implicating materials against the incriminating materials against the petitioner number 1.
My lord.
However, it is
Excellent.
submitted that the injuries sustained by the victim is simple in nature and caused by blunt object. It is also submitted by learned additional public prosecutor that the injury report does not suggest that any stitches were put to the injuries of the victim as alleged in the FIR. Stop. Considering the and statement record,
My lord.
whether statements of it
A complainant statement is there, my lord. And other, my lord, this is also there. I have taken my.
stop. I have considered the submissions made by learned counsel for both the sides and have perused the case diary. Considering the fact that the investigating officer has recorded the statement of witnesses, including the victim, and also considering the fact that the injuries sustained by the victim is of simple nature, custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of the case. Hence, both the petitioners, namely Suleiman Elias Suleiman Ahmed and Mansoor Elias Mansoor Ahmed, are hereby directed to appear before the investigating officer of Murajhar PS case number 223/23 within a period of 10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, the above named petitioner shall be allowed to go on bail of fees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Both the petitioners shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair investigation of the case. Stop. They shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the investigating officer or to any court. With above observation, this anticipatory bail application is thereby disposed of. Send back the case.
Last reply.
May I please, Lordship, as per office noted dated 17/11, Lordship, LCR has not been received.
Third, Miss
P. Adhikari.
P.
Adhikari.
Learned counsel for the petitioner. It appears from the office note dated 17/11/2023 that the scanned copy of the LCR, which was the requisition, has not yet been received. Registry to issue reminder for the scanned copy. List this matter after 3 weeks.
Item number 21.
Well, this is a quashing petition
for non-compliance of section 17A of Prevention of Corruption Act. Now, my lord, before commencing my argument, my lord, I will like to draw kind attention of the honorable 17A. 17A of Prevention of Corruption Act.
17A says that no police officer can investigate an offense if the alleged offense is relatable to the recommendation made or a decision taken by a public servant in discharge of his official duty. That is the reading of section 17 of CCA. So offense has to be in relatable to the decision taken or recommendation made by a public servant. So that is the criteria. Okay.
So may I read,
Here
my
is-
lord, before my friend will have his say. Inquiry, my lord, there was a stage when the legislature, in its wisdom, thought it prudent to induct section 17A and specific amendment was made in the PC Act, my lord. Inquiry or investigation of offences relatable to recommendations made or decision taken by a public servant in discharge of official functions or duties. No police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act. It is very important, my lord. Under this act, where the alleged offence is relatable to any recommendation made or the decision taken by such public servant in discharge of his official functions or duties without the previous approval of. Then, Lord, ABC is mentioned.
Sanction is required.
Sanction is required. Sanction is required prior to investigation by the police. Okay. If the offense is relatable to the decision taken or recommendation, these are the criteria. These two are the important things. The offense has to be relatable to the decision taken or the recommendation made. So here in this case, let my learned friend argue. I'll
Absolutely, my lord. Now, my lord, then further, my lord, what my learned friend is saying is answered in the proviso itself. Provided that no such approval shall be necessary for the cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. On the spot, my lord. That is very important and very relevant. It will be discussed before my lord. Now, my lord, there are few dates which are relevant to this case. My lord, the petitioner before my lord was working as a regional officer of NHAI.
Highway Authority.
National Highway Authority of India. He is a general manager and he was working here as a regional officer.
Yeah.
Now, my lord, a contract agreement between NHI and Messrs. GR Infra dated 29/9/2015 was executed. That date is important, my lord.
29/9/2015.
I am not the signatory to that contract. That was entered into by NHI and Miss. This is in regard to rehabilitation and upgradation of existing road to lane 2, paid soldiers from in Jowai, Meghalaya, Assam border, my lord.
Before you proceed further.
Yes, my lord.
What was the allegation against you?
That is precisely, my lord, we had filed the charge sheet. Now, my lord, on 12th of June 2022. Two officers of NHI were arrested taking bribe.
Taking bribe.
Yes, my lord. Two officers of NHI were arrested on 22nd 6 2022. I am not that officer.
On which date?
12th June 2022, my lord. Now, my lord, they prepared a detailed trap memo. All procedure adopted therein, all things stated by them, all narrations made by them. I am not the person for whom that money was received. I am not the person for whom this money was taken. I was not even in the loop regarding that. There is no allegation that this money belongs to me. That document is on record, my lord. We have placed. If my lord will have the CBI trap memo.
At page?
That is, my lord, on page number 624. That, my lord, will find in our replication. Rejoinder, my lord. So in this trap proceedings, recovery memo, my name is not even mentioned, my lord. Forget about any allegation.
Okay. Yes.
And it is not a single page or double page memo, my lord. It is exhaustive memo wherein statement whatever was narrated by the persons who were arrested, who were taking bribe, or who was giving bribe. Everything is mentioned. There is not even whisper against me in these proceedings, my lord. This is on the basis of these proceedings. They register the instant FIR, my lord. On the basis of after making these proceedings, they record FIR is registered. That is RC, my lord, 16 RC 216 of 2022.
Where is the FIR?
Yes, my lord. That is, my lord, subsequent thereof.
You are praying for quashing of the FIR.
Quashing of, my lord, charge sheet
Charge sheet.
against me, Kwame. I am only confining it to myself, not regarding, not of against the other co-accused, my lord. FIR is, my lord, on page number 633. I am not named in this FIR. Various officials are named, but I am not named in this FIR, my lord. Now, my lord, date is important. The act says if I am arrested from the spot, then all right. But if I am not arrested from the spot, then, my lord, The legislature intention is clear. It is unambiguous. It is specific. It says, my lord, proviso, provided that no such approval shall be necessary for cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. So it is important, my lord. In this recovery memo, I am not arrested. I am not arrested from the
No,
spot.
what is the charge against you?
My lord, the charge against me is that I, being the RO, I was in discharge of my official duties. I was to release bank guarantee of this entity. And for that purpose, I had asked them to get a job for my relative in that entity. That is the charge against me. Secondly, they say that I was trying to get money and all narration, though it is in the charge sheet, but it is not supported by any evidence. No evidence to that effect that anybody had handed over me any money or at any stage I am in receipt of any money. There is no document. Then they say that in discharge of my official duties, I use my influence to get a favorable order for this company for the purpose of releasing the bank guarantee. That is the charge sheet that I will read, my lord. They say that I used my influence, my capacity, and got the report changed and favored this entity.
Which entity?
GR, this entity, my lord, for whom the GR Infra. GR Infra was awarded the contract. I am not a person who awarded that contract. That was by bidding.
How then this trap case is related?
That is, I am at my wit's end to understand, my lord, that how this trap case is related to me.
Whether they have mentioned in the charge sheet that
They have mentioned in the charge sheet, my lord, that I was trying to take money, trying to take, they collapsed many officials, that officer so and so, without making any specific allegation that from whom I was trying to take benefit. That is not even whisper of allegation in the charge sheet against me. It says that officer so and so, the two officers who were caught red-handed, none of them has stated that this money was for me or this was for to be handed over to me. None of the.
What is that the allegation against you in the charge sheet that this money was for you?
There is no allegation against me regarding this money, my lord.
Then what is the allegation?
Allegation, that is precisely what I said, that the allegation, my lord, I will read. I have put the next charge sheet is appended here, my lord. So in FIR, I am not arraigned as an accused. Before, my lord, I will wish to bring on record what my learned friend was saying, that this was in regard to that only, confined to that only. Now, there are few judgments of this Honorable High Court also and various other Honorable High Courts on this subject, my lord. I have given. I had filed it.
No, Mr. What is your name?
Sanjay Man, my lord.
Before coming to the judgment, you have to narrate the facts very clearly.
Yes, yes. Facts are specifically mentioned, my lord. I will read the charge sheet. Charge sheet is appended. I have
You
filed.
have not yet come to the charge sheet which
Yes,
you
sir.
are praying for quashing. in
Yes,
this
my
case.
lord. Before that, my lord, coming to the charge sheet, only for a minute, my lord, I will request the Honorable Court to look in, my lord, kindly see page number 137 of the petition. That is a bulky agreement, bulky document, but it is only relevant is only one part of this.
137.
137, my lord.
What is this document?
This is the contract agreement entered into between NHI and my lord,
915.
yes, ma'am.
How it is relevant?
This is relevant, my lord. This is regarding the allegation against me. Release of performance performance security, my lord. Kindly see, my lord. The authority shall return the performance security to the contractor within 60 days of the letter of the expiry of the maintenance period or the defects liability period under this agreement. Notwithstanding the aforesaid, the parties agree that the authority shall not be obliged to release the performance security until all defects identified during the defect liability period have been rectified.
Yeah.
So, my lord, the agency, the authority was under obligation, under contractual obligation to release the performance security to the contractor within 60 days of the letter of the expiry of the maintenance period or the defect liability period under this agreement. So that is a limited purpose for this, that I was under the NHI was under the obligation once the contractor's period is over within 60 days. Otherwise, I will be NHI will be recurring.
So you release the performance security.
After following the due process, my lord.
And that is the allegation against you, that you favored someone by
That is their initial. They says that there was unfavorable report. I made that favorable. I told him to make it favorable, and then under my instruction, they gave me the favorable report, and I released the bank guarantee. That is the allegation against me. And that was done after the period of 60 days, my lord. After the defect liability period. Now, kindly, my lord, one relevant para. One relevant para, my lord, in this agreement also. There is another 185. Kindly, my lord, for a minute, if my lord will have, then I will straight will go to the charge sheet, my lord.
Page number?
185. (1992). In the event of failure of the authority to make payment to the contractor within the time period stated in clause 19(9), the authority shall be liable to pay to the contractor interest at the base rate of +2% calculated at quarterly rates on all sums remaining unpaid from the date on which the same should have been paid, calculated in accordance with the provisions of section 1991 A and B until the date of actual payment. So, my lord, here it is an agreement between two entities. It is neither master or servant service relations are not there. Both the NHI and the contractor are on the same footing. If we make any mistake, we are also liable to pay. NHI will pay the compensation, will incur financial obligations on account of any failure on the part of NHI to discharge its obligations as per the contract entered into between the parties. Then, my lord, on last date of hearing, I had submitted one email that was forwarded to all officers of NHI, my lord, by NHI. My lord will, if my lord will have, otherwise, my lord, this is email address dated 11th January 2022. Kindly have for a minute, my lord. This is prior to that bank guarantee being liable to be released or anything of that nature. This is circulated by the NHI to its officials, including me, my lord.
What it says?
It says, my lord, if there is any delay on part of any official in discharge of bank guarantee, it will be taken seriously and I shall be personally liable. The officer concerned shall be personally liable. So, my lord, before the date on which the bank guarantee was due and liable, it has already been intimated to us by the authority that bank guarantee has to be released within the stipulated time. Any delay in the release will be taken seriously. And, my lord, seriously means my career, my promotions, my ACR, my lord. Now, under these circumstances, my lord, I cleared the bank guarantee. Now, my lord, they in the charge sheet itself, what CBI has done, mentioned few things and concealed many things and concocted certain new aspects. Now, my lord, kindly see if my lord will have the charge sheet. Charge sheet is on page number 35, my lord. And relevant portion start from, my lord, page number 47. May I read, my lord, section 16.2, that it was alleged that Messrs. RGR Infra Project Limited was awarded the road bridge construction tender in the jurisdiction of NHI Regional Office, Guwahati, and Shri Sushil Kumar Verma, Manager Technical cum Project Director, is monitoring the aforesaid work. Accused Sunil Kumar Agarwal, Executive Director of Messrs. GR Infra Projects Limited, is maintaining regular contact with officers of NHI for obtaining favor in the matter of processing and payment of bills. So now, my lord, we have a peculiar situation. If an officer is contracting, there is an obligation as per contract that once the bill is given it to us, it has to be cleared within 30 days. That clause I will read, my lord. Release the bank guarantee, etc. through corrupt and illegal means with the help of accused Shri Pankaj Singh, an employee of GR Infra Projects Limited. All the bills as well as applications for release of 2 performance guarantee were processed by Shri Sushil Kumar Verma from PIU Shillong to Regional Office Guwahati for payment release. Accused Sushil Kumar Agarwal requested himself to Shri Alok Kumar, my lord, the petitioner before my lord.
This is for the first time your name is coming.
Yes, this is in charge sheet, my lord.
Okay.
Alok Kumar, Regional Officer of NHI, RO Guwahati, and through Shri Pankaj Singh, also to expedite the release of bank guarantee of Messrs. GR Infra Project Limited. So allegation against me is in regard to the release of bank guarantee, 2 bank guarantees. And got assurance from Shri Alok Kumar to get done all his pending work done. Now, my lord, I am a regional manager. What I will say to my contractor, I will not clear your bank guarantee. You go. If I say I will clear with the bank guarantee, I am corrupt. I am in under contractual obligation. My department says it has to be cleared within stipulated time.
Within 60 days of the completion of.
Within 60 days of the completion of the maintenance period. And that is, my lord, it is done thereafter only. That is, I will thereafter. Shri Alok Kumar also conveyed to accused Shri Sushil Kumar Agarwal that he had ensured that the authority engineer from Messrs. EGIS India Consulting Engineers Private Limited will recommend the release of bank guarantee worth rupees 10 crore and subsequently on 27/4/2022, Shri Pankaj Kumar confirmed to accused Sushil Kumar Agarwal that one of the BG has been released by the RO. NHI. Apart from the aforesaid one BG, Shri Sushil Kumar Agarwal asked Shri Pankaj Singh to apply for release of residual BG amounting to rupees 2.5 crore and thereafter on date is important, my lord, 13/5/2022, Shri Pankaj Singh confirmed to Shri Sunil Kumar Agarwal that the bills have been submitted to PDPIU and same will be forwarded to RO office Guwahati for payment. Now, as far as the bill is concerned, my lord, there is no allegation or even I am not in charge of payment of bill. In the authority, my lord, payment of bill is not to be looked by me. It is done by the project director or those persons who were arrested. It is further alleged that on being asked, Shri Sushil Kumar Agarwal, Shri Pankaj Singh shared the details of illegal gratification to be made to the officers of project bribe to regional office of NHI, RO Guwahati was allegedly paid and the further payment of illegal gratification to regional officer NHI Guwahati will be done for release of bank guarantee. However, Shri Sunil Kumar conveyed his displeasure to Shri Pankaj Singh on the large amount of illegal gratification to be made to NHI officials and asked him to revise the same in consultation with Shri Dilip Rajput. Thereafter, on 31/5/2022, Shri Dilip Rajput confirmed Shri Pankaj Singh about the approval of the aforesaid illegal gratification for NHI officials to be paid and assured to deliver the same shortly. On 1/6/2022, Shri Manoj Kumar, after having discussed with Shri Deepak Das, demanded illegal gratification of rupees 6 lakh. Now, these are officials, nothing to do with me. If somebody is demanding money, those 2 officials were arrested by the memo that I initially demonstrated. In that memo, not even my name is not even mentioned. There is no confessional statement of these 2 officials that this money was for me or at my behest or at my instruction. It is also alleged that despite the initial adverse remark by Shri Ashok Kumar, engineer, Messrs. EGIS India Consulting Engineer Private Limited, consultant for monitoring the project against the BG bank guarantee release of Messrs. GR Infra Project Limited, accused Alok Kumar, RO NHI Guwahati, in short, positive report of Shri Ashok Kumar Singh. So there.
Who is Ashok Kumar Singh? Engineer.
He is a, my lord, what,
Is a contractor or engineer?
what NHI do is, NHI enters into an agreement with the contractor. Now, as far as supervision of that work is concerned, it enters into an agreement with a separate consultant agency. That is, my lord, EGIS, and my lord, about 9 crore rupees are paid to this entity for supervising the project and recommending the release of bills and if there is any deficiency thereof. So these are independent agency in the form of auditor, engineering auditors who look after the project, who makes their recommendations to the NHI. The bills are forwarded and circulated to NHI through these agencies, my lord. They forwarded it to NHI. Bills payment is concerned, it is done at the stage of project director, my lord. It is not at my stage. And my lord, as far as the BG is also clear, it is recommended by this Ashok Kumar.
Who is Ashok Kumar?
Ashok Kumar is the official who was assigned by the EGIS consultant.
For what purpose?
For the purpose of this project, my lord. Subject project was Ashok Kumar was official of Messrs. EGIS.
Then what it means that you ensured positive report of?
That is the inference drawn by the CBI, my lord. I will show those letters which have been recommendations made by, to which they say that unfavorable report was made to NHI regarding this project. I will show that report, my lord. We have annexed that report. That report, before proceeding further, my lord, let us have that report which they say that there was unfavorable report by Mr. Ashok Kumar, and which I use my influence to get it to favorable.
How much time will you take? It will go long.
Lord, it will take some time. Because there are certain, what is there, my lord, in this case? I am an officer who was responsible for building of the roads in Northeast. I had built, my lord, various roads, and I had documents, various recommendations by all bureaucrats and all politicians, my lord.
Now, till now, 2 allegations against you.
Yes, my lord.
One is that Sunil Kumar Agalwara requested you to release the payment.
Not payment, my lord, bank guarantee.
Bank
Release
guarantee.
bank
That was
guarantee.
the first mention.
Yes.
And second is that accused Ashok Kumar, you ensured positive report of Ashok Kumar.
Yes, my lord. That I will demonstrate, my lord. Both of that, there is no let us start with the report. If there is my lord, these are two interlinked, intermingled allegations. If the report was clear, if the officer is recommending, auditor is recommending that release the payment, I am duty bound to do it, my lord. If the officer is Ashok Kumar is saying that you release the payment, bank guarantee, then I am duty bound. If I am assuring, if I receive a call, if mera bank guarantee release kar do, I am duty bound to release. If there is no impediment in that, I will not say.
What it means that you ensured positive report. No.
That is precisely, my lord. First of all, their contention is that I use my influence to convert a negative report by Mr. Ashok Kumar to a positive report. Let us see what is the negative report and what is positive report. The case of the CBI hinges on these two documents, 2 letters. They say initially the report was negative. Then I used my influence and I scolded him and I told him no, not to do not to do these things. And then he changed his report, and on the basis of that report, I released the bank guarantee. That is absolutely contrary to record, my lord. Now let us see what is there, this report. If my lord will have page number 602, my lord, for a minute. 602, my lord. That is in our, my rejoinder method. Now, my kindly see, my lord. This is rehabilitation and upgradation. That project is mentioned. This is addressed to by the EGIS. That is independent consultant hired by.
Is this?
This is, my lord, the independent agency that is assigned the task by the NHI to oversight and to supervise the work.
Evaluation by.
Yes. So they are the persons who are authorized by NHI, and I am not the person who has entered into the agreement with them, or it is not at my stage that engineer is audited. This engineer is determined. The and agreement is entered into. About 8 to 9 crore rupees are paid for this project to these engineers to only for the purpose to supervise and to ensure that all things are done properly and in a systematic manner. Now, my lord, kindly see rehabilitation and upgradation of the existing road to 2 lanes. This is the, my lord, project. This is letter is in regard to this. Now, kindly see, my lord. What is it? What is their recommendation? If my lord will have recommendation in para number 606. Last para, my lord, last but second last para, my lord. In anticipation of the correctness of the amounts previously made by the authority and verification of the GST impact amount due to change in law as stated at para number 10. My lord, GST rate changes, so therefore on this account it is mentioned. 1. Above at PIU, the authority engineer hereby recommend that the contractor is entitled for the net payment of rupees such and such 13 crore 53 lakh 54,568 after effecting all statutory recoveries such as income tax, labor cess, GST, etc. towards final payment certificate as per clause 1952 of the EPS contract agreement. So, my lord, what I read it, what I understand from this is, he says this amount is recommended. Now, kindly see, my lord. Next. Then there is a letter dated 27/5/2002, 22, my lord, on page number 599. money. This is regarding same address to the project director. I am not the project director, my lord. Both these letters are addressed to the project director. Sorry. Now kindly see, my lord, for in the column of reference. Refer. At serial number 3 of the reference, my lord.
At same page.
On the same page, 599. On serial number 3 of the reference, EGIS India Joy so and so dated 20th May 2022.
Yes.
Now, this is the same letter that I was reading, my lord, earlier, wherein it says that this amount is recommended. He say, if my lord, this will be very pertinent. He says, the authority engineer hereby recommend that the contractor is entitled to net payment of rupees 13 crore 53 lakhs 54,000. So such and such amount. So he there in this letter dated 20th May 2022, he says recommend. The word used is recommended. Now kindly see in this letter at serial number 1, my lord. Net payable amount of rupees 13 crore 53 lakh 54,568 as shown but not recommended. He is referring to letter dated 25th of 20th May.
Which is at page 60.
That is on page number
606.
602, starting from 602, and my lord, the relevant portion is on page number 606. Second line, my lord. The above PU, the authority engineer hereby recommends that the contractor is entitled for net payment of rupees.
Yeah.
Here he says, I recommend.
Yeah.
And in this letter of 27, after 7 days, he writes that net amount payable, net payment payable amount of rupees 13 crore 53 lakh 54 as shown, but not recommended by the engineer. Now, if I call him authority engineer, okay, boss, what are you doing? This will create problem. You initially you are recommending. After 7 days, once I act on that, and after 7 days, you are saying amount payable but not recommended. He is referring to letter dated 20th May.
In between, you have already released.
In between, amount may be released, my lord. This is not my task. My only limited role was I asked him, okay, boss, don't do this. If you are recommending, you recommend. If you are not recommending, don't recommend. But you can't do this. That in earlier letter you say you are recommending, and in the subsequent letter you say amount payable is this. Even in this letter, he says the net payable amount of rupees so and so as shown.
These
But
both are letters from Ashok Kumar Singh.
these are 2 letters from Ashok Kumar Singh. That is what they are saying, that I use my influence to get a favorable report. That is what they are saying. Now kindly see. What he further says, the engineer final payments statement with a engineer letter dated cited at serial number 3 above dated is not the fixed amount but and subject to vary due to following. Kindly see, my lord, I will read again, my lord. The net payable amount of rupees 13 crore so and so but not recommended in the engineer's final payment statement with a engineer's letter dated at reference number 3 above dated 20th May 2022 is not the fixed amount and subject to vary due to the following. But
So after recommending, he is now changing his stand.
no, we did not pay him 13 crore rupees. We did not. 13 crore rupees was subject to all statutory deductions, and the payment was released only after making all statutory deductions. The whole, my lord, it is not the case of CBI that NHI had suffered even single penny loss on the account of this. I had obtained information at RTI from the department. They say not even single rupees loss has been accrued to the NHI. CBI did not go and check it from the NHI whether you accrued any loss on account of this. They draw their own inference.
No, Mr. Moore, by showing these two letters.
Yes, my lord.
At 606 and 599.
Yes, my lord.
Which point you want to emphasize?
I want to draw this attention of this honorable court to the point that they say that I used my influence
To
in
get a favorable report.
getting
from
a
Ashok
favorable
Kumar
order.
Singh.
Now, out of these two favorable or unfavorable reports, what is the favorable report and what is unfavorable report? They say that letter dated 20th is unfavorable to me or 27th the letter is favorable to me. None of that. It is, he says recommended, and even in this case, he says, kindly see my lord his language, the net amount payable, the net payable amount of rupees so and so, as shown, but into bracket, but not recommended in the engineer's final payment statement with a engineer's letter dated, cited at reference 3, about dated 20th May 2022, is not the fixed amount and subject to vary due to the following: the applicability of 12% GST on bonus of payment balance, the genuineness of the balance GST impact on such and such amount. Prior to release the final payment, the contractor has to confirm and submit the quantum of minerals used for the above project. Then, my lord,
So in the charge sheet, these letters were.
these letters are part.
IO were referring to this letter when he referred to you that you got favorable report
So
from.
that is only favorable the document report. They are the part of charge sheet. If my lord will see D81 of that is part of the charge sheet, and also
These are. Furnished along with the charge sheet, D81.
yes. Now, what my learned friend has done, he had annexed and appended with certain statement and statement of Ashok Kumar Singh also, wherein he has not stated that he has not changed. He had made a specific statement that he has not changed his statement recommendation. So therefore, the contention of CBI that I use my influence, their own witness says that he has not changed his recommendation. Specifically says. And then, if Ashok Kumar Singh has not changed his recommendation, if NHI don't say that NHI has incurred even single rupee loss on account of the payment, because final payment, once final payment is made, then only bank guarantee will be released, my lord. Then, my lord, these two recommendations. Now I read some part of the charge sheet, wherein, if my lord will have page number 57. If my lord will have the index on the at the bottom, payment of interim payment so and so, in payment made in 2020, payment of interim payment certificate dated 11/2/2022. Then my lord important release of performance bank guarantee amounting to rupees 11 crore 68 46 lakh 81,000. Date is important, my lord. 27/4/2022. And on para number at serial number 8 and 9, my lord. Payment of final bill of rupees 4 crore 84 lakh 7,364. Ashok Kumar Singh's recommendation was 13 crore rupees deductions, and my lord, that was duly complied with. After deductions, 4 crore 84 lakh 7,340. Payment release, my lord, is important. 31st May 2022. The release of performance, then that is this serial number 8, I have nothing to do with it. And it is not even the allegation that I had anything to do with it. 8. 9 is concerned, my lord, release of performance bank guarantee amounting to rupees 2 crore 58 lakh. Date is important, my lord, 9/6/2022. So first tranche of bank guarantee to their 2 bank guarantees was released on 27/4/2022, my lord. And second was released on 9/6/2022. Now, my lord, when and how they had become due and payable. If the charge sheet, my lord, will see. It is CBI themselves mentioned in para number 16/7, my lord. Page number 49. Page number 49. Investigation revealed that on 10/9/2015, a tender was awarded to Messrs. GR Infra Project Private Limited by NHI for the project such and such at total consideration amount 468 crore 27 lakh. And then, my lord, due to the pandemic, earlier, my lord, banks, the performance guarantee was 7.5%. Then the department thought it prudent to reduce it from 7.5 to 3%. So therefore, those bank guarantees were released, and only 2 bank guarantees were maintained, kept. 2 bank guarantees, 5th line from the bottom. 2 bank guarantees worth rupees 11 crore 46 lakh 81,000 dated so and so. Amended dated so and so, ground so and so, and dated so and so and so. So though only 2 bank guarantees were kept. Now, my lord, Messrs. Aegis India Limited, their role is assigned, discussed on para number 16/9. Investigation disclosed that NHI has appointed a company, namely Messrs. Aegis India Consulting Engineers Private Limited, having address so and so, Haryana for monitoring and supervision of the above said project for the initial amount of rupees 8 crore plus service taxes, which was increased to 9.7 9 crore 7 lakh rupees plus service taxes payable in India. So that is, I have nothing to do with it. Then, my lord. Point 16.10 investigation disclosed that as per the stipulated conditions of the said contract agreement, NHI shall make interim payment to the contractor, Mr. So-and-so, as certified by the authority engineer, Mr. So-and-so. So, every payment certified by the engineer has to be made within stipulated period on completion of stages as given in the contract, and such payment shall be made no later than 30 days from the date of submission of the stage payment statement by the contractor to the authority engineer for the certification. The payment of final bills was to be made within 30 days of receiving the final payment settlement for the works, and thereafter the contractor had to submit discharge to the NHI showing the receiving of the full and final payment of all dues from the NHI. After expiry of the maintenance period of the defect liability period, the NHI authority shall return the performance guarantee security to the contractor. However, the contractor was bound to rectify all defects identified during the maintenance period. Now, my lord, I pause here for a minute. In whole charge sheet, in whole endeavor to frame me, CBI has not shown when and which date any deficiency was found, any deficiency was pointed to contractor by the EGIS or by NHI.
Deficiency on the part of the contract.
There was no deficiency, my lord. That is why it is independent agency which is checking, and it is not checking one project. They are doing it for various projects, my lord. This EGIS is this is 400 rupees, 400 crore rupees project, my lord. NHI is doing 22 lakh crore rupees project, my lord, countrywide. In this petitioner before my lord has done more than 20,000 crore rupees project in northeast states only while he was here. My lord, there are situations. Now they say that I use my influence. Then another allegation in this FIR charge sheet is that I use my influence and rang up somebody. You purchase the machinery which is rendered useless for these people and you repair my project, my road. Because of landslide and rains, there was some trouble, my lord. There was some other contractor because their project is completed. Their project is completed. Their machine is lying useless. I rang up somebody else who required the machinery urgent. My lord, we are the road maintenance is not a task which is. We had received communication from the Chief Minister's office. We received communication from various states and various agencies, which says because of floods and because of the damage on road, there is deficiency of food grains. There are on the bordering areas, road is not approachable for 4 days, 5 days. So under these circumstances, my lord, I have to, as a RO, has to use my influence. Ask somebody, request somebody, boss, can you have made, because if the machinery is to be brought from Delhi or Pune, my lord, it will take more than 1 week, and it has to be arranged within stipulated time. And sometimes road is in such bad shape that machine even cannot be brought from outside. It has to be procured from that area only. And if I rang up somebody, कि boss आप उसको machine भिजवा दो, then I am in suit. Because under their interpretation is that you do it, whether it is done or not done, you sit idle. And that is precisely what had happened, my lord. Subsequent to this case registered by CBI, the department has no officer was eager to take release bank guarantees. And then department has to, ministry has to call all the officers, the chairman has to intervene and issue circular to all the officers. Okay, you have to do it within 1 week, otherwise we will take action against you. Because no officer, if I release it, then I am liable. CBI will say that you have released, you are hand in glove with that officer. If I don't release, then they will say, since you were expecting undue advantage, therefore you have not released it. And that is precisely the intention of legislature, my lord, and which has been dealt with by honorable various high courts, my lord. The earlier Chief Justice, Honorable Chief Justice of our Guwahati High Court itself has dealt with this issue, my lord. I had handed over, my lord, the judgment. If my lord may read.
Some more, we have to stop.
My lord, I am Man, Mr. Moore is
You are Mr.
Man, my lord.
Sorry.
Man.
So how much time will you require more?
My lord, because it is, I will take half an hour, my lord, more than I will
Not
consider.
today.
Any date, my lord, convenient to my lord.
Mr. Haloy, how much time will you take?
Lordship, half an hour.
Because I will have my own query.
Yes, yes, my lord.
Then it will take more than 1.
It will take more time.
May I submit, my lord, I submit my judgment and a brief note that I prepared, my lord.
Yes, you give your submission in bullet point.
Yes, bullet point, only 6 pages, my lord. And
What are the acquisition, on what ground you are challenging the charge sheet?
yes.
Then
Yes,
you may make any submission.
Yes.
So before next date, you give your submission in writing, gist of your submission in
Yes, ma'am.
bullet point.
That I will do. That I
Then
will.
there is a hope of
Yes, sir, yes, definitely, my lord.
when shall we fix it?
At the earliest, my lord, any early date will be.
Lordship, already matters are fixed in this coming week. Lordship. Let it be on December, first week of December.
On there, we fix.
Lordship, first week of December, Lordship. Any date, Lord.
What is to be done? Shall we keep it part heard?
Lordship may
Yes,
keep
my
it
lord, may
partner
keep
because earlier, Lordship, Justice Edith Chaudhary.
Because somebody has heard it
Yes,
and left it.
Yes,
yes.
sir. Justice Edith Chaudhary has heard it.
If I
And-
do it same,
Then it will
this
be
process will
wastage
continue.
of judicial time, my lord. Precious time, my lord.
The last occasion, Lordship, Justice Chaudhary has told us to submit some gist of the case, Lordship, by submitting of the relevant statement of the witnesses and all, on the basis of which prosecution has relied to register this case. I have already prepared and submitted a copy to them also. 4 copies with me. But last raised in the before Puja vacation, Lordship. So court instructed to hand it over to the next court. So it's not raised.
Okay, then without making it part heard, we may fix the date.
My lord may keep it part, my lord, because
Otherwise it will.
it will be wastage of judicial time, my lord. We are happy to argue, but
Yes.
this
Heard-
honorable court has heard it.
Heard, Mr. K. What is your name?
Sanjay Man, my lord.
Mr. S. Man, counsel for the petitioner, also heard. Mr. M. Haloy, Special Public Prosecutor, CBI. The hearing remain inconclusive. Let this matter be listed again on.
Well,
Fifth, Lordship, fifth December.
I will not.
Then
first,
After
after that, then 4th December or
4th December,
sorry, 14th or
14th, 15th also, Lordship.
after this
4th
is-
December is fine.
14.
14th.
14th is fine.
Let this matter be listed again on 14th of December as part of it.
Grateful.
Hallelujah.
Grateful.
My lord. Victim mention item 52. Last occasion also, due to paucity of time, it cannot be taken up. Can it be taken up on the next Tuesday, 28th?
No, now the court master will give you dates. We have to see our board again. It will. We have to fix cases so that it may be taken. So only court master will help. Third, learned counsel for the. No, this matter could not be taken up due to paucity of time. This matter on so and so date. Date would be given by court master. The interim order, wherever there is interim order, the interim order shall continue. Now, anything which is not covered by this order.
My lord, item 24, my lord. The scan copy of the LCR was called for, my lord. They must not be received, my lord. Reminder me.
In 24,
May I please, your- my urgency is that the petitioner is behind the bar last more than 8 months.
all are.
That is why I want to fix a date, Logic.
No, she will give date.
Keep your like.
Item.
I'm also paying. No, if it is possible, the court master.
Yes. Lordship, I have a submission to make in item number 46. Item 46, Lordship, we have taken step to the person number 2 by way of registered post and to the district magistrate and as well as the to the officer in search concern. But none of the services were returned, some are yet to be returned. That is my difficulty, Lordship. So it is the next date before the learned trial court. It is fixed on 8th of December for a statement of defense. We have challenged the order of framing charge only for the non-service of the notice of the on the informant respondent number 2. The case is being lingered. So may I pray, although it is not permissible in criminal proceeding.
Is
Lordship,
there any bar?
no, Lordship, already the court has taken has taken a view. So
Justice service is not.
Justice service. So as an exceptional case, may I be permitted to take a justice service?
No. You mentioned tomorrow morning. Showing that there is whether there is any bar or whether justice service may be permissible under this act. You convince the court and then let this court.
But I don't want 22 9 proper